All right, welcome to the Deschutes County Board of Commissioners meeting. This is for 9 a.m. Wednesday, July 26th, 2023. First item on the agenda is Pledge of Allegiance. Please join me.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next is citizen input for items not on the agenda. We have three requests to speak at this time. Mr. Doug Hochek. Got you up here first. Yep.
Good morning. If you don't mind, I'll stand up here because I have things to pass out to you. I met with Mr. DeBone about a month ago. I live in Sun River.
If you could get on the microphone, yeah, we're gonna need to.
I live in Sun River. I've been there since 2017, working and trying to correct what is really a very dangerous wildfire consumption of lodgepole pines. It's involved a lot of things. We created 2222, the new legislature with our senators, and 762. I've been fined $17,000 for removing trees that actually had permission to remove from the general manager who retired, and Sun River lost the evidence. I'm going to just present this to you and leave it with you. Your inspection.
Thank you, Doug.
Now it'll be in the record, yes. So this is a 3-minute testimony. We're getting to be into the first minute, just letting you know.
This is the tree that was given disease with beetles. We took these down with permission from the general manager on it. His approval, he retired, and it was lost, and this is what we got. I'm fine. For 7 trees, it's $17,000. This is our home. Golf course and all the forest still behind it. With other homes that have trees 3, 6, 8, 10 feet away. And they will not let them take them down. Leaving this with you, if you will please. This is the area where there's a huge tree in front of our home. This is FEMA, who has published a report what they want us to do with 30-foot spacing. I read this to protect myself. I was told this is industrial and Patty refused to do it. I'd like you to keep this in your records if you may.
You can just set it over here.
Because everybody in Hughes County needs to understand what FEMA is doing, because we really don't. And that's a fact of life. So, this is the home with the big tree that you see now is removed. And this is what the commissioners in Salem use. Your home's more important than a tree. And that's why 2222 got down.
So Mr. Hochek, that's 3 minutes for the testimony period. Let's wrap it up.
2 seconds. Sun River was divided when it was built. The villages of private property. I bought a lot by private property in the village. The SROA has dismantled the village without voting. They now use the common area, the tree forest, which is what I was trying to deal with. Because our property stops at 21 feet, 7, 12, 100 trees up and down all over. They're in there. They're diseased like what I showed you. And if that doesn't get cleaned out, and there's a fire like we're seeing now, you're gonna see things bigger than paradise. I don't know what else to do. I paid the fine. I came here Because I believe as a citizen, I cannot be treated that way. I have rights. Gun River pays the Deschutes County taxes. They pay taxes for the rentals. 25,000 people a day are there under this danger with their kids, grandkids, and grandparents. If we don't stop it, and the fire is going to come on, you're all over. It has to stop. You're the only legislative forum that can stop this. Salem is too busy and too confused to individualize this, and they've told me to come here.
Thank you for your testimony today.
Any questions?
No questions. Thank you for joining us. Mr. Rambozell.
Morning, Commissioners. I'm Ron Buzel. I've lived in Central Oregon over half my life and in Bend. We have some issues and we have hard times. We have great opportunity in front of us. And so I'm going to just talk about a couple of real quick things that need larger conversation, I believe. They are both at core, I believe, to our homeless issues in Central Oregon. One is dangerous dogs. And I'm not going to define that, but my solution as a starting point is enforceable code in our city and in our county. Enforceable code. What we have now is not adequate and does not address our issues and certainly does not address the murder of our local last week. I cannot bear the thought of this happening again, nor can I fathom this happening to a child that is also living in the midst of these situations where dogs are running free and unlicensed, unregistered. So we need to have a campaign, I believe, a marketing campaign. And my very sweet lab pet will be first in line to be registered. And I confess that my 2-year-old is not yet. And so this has been an education process, and I want this to be an opportunity for us all to be educated, but the opportunities are in front of us. The second, nobody wants to talk about this, is meth crime. There is meth culture at the center of our homeless gatherings. I know this because I've been homeless for about 8 years in Central Oregon myself, living on the street, having relationships with a lot of these people who are our neighbors, friends, relatives. They're not just imports, which is a real fabulous rumor these days that people are just coming here for their services. This is ridiculous. We have meth crime and we must address it. We have already the laws necessary and the resources necessary to take care of it. This is like surgery now. It can get ugly and it can get bloody, but it's necessary. Thank you for your time and consideration.
Thank you for your testimony.
Thanks, Rando.
Mr. Carl Shoemaker.
Good morning. There was a man one time in Europe named Schindler. He was a weapons manufacturer. He manufactured artillery shells. And there were a group of people that the government hated. They wanted to wipe them all out. Well, Schindler wouldn't have that. So he said to the government, have those people come work for me. I need them to work. And so they survived the war. Another man kept a couple of families in his house in a secret room. And a little girl kept a diary. He was caught out. He got in trouble with the government. overseas in another country, there were people that were oppressed in the South. And some farmers would have these people that were trying to escape stay in their barns overnight as they moved north, just to get to safety and freedom. Sometimes you just have to break a law. Any which way you can. Every which way but loose. By any means necessary. Thank you.
Thank you.
Hey, Carl.
Is there anyone else for citizen input? Is there anyone online? Raised hand feature? Seeing none. I want to thank everybody for your testimony today. At this time, consent agenda.
I'm so move approval.
Second. Any other discussion? Seeing none, Commissioner Dare,
Yes.
Commissioner Chang,
Yes.
and Chair votes yes. Thank you. At this time, item number 6, public hearing on Senate Bill 391 and 644, rural accessory dwelling unit legislative amendments.
Good morning, Commissioners. For the record, Kyle Collins, Associate Planner. If you'll give me a second here, I'm going to share my screen so we can run through our opening script.
I can get this first statement from opening up the process here. So this is the time and place set for hearing on file number 247-22671-TA concerning legislative text amendments to allow rural accessory dwelling units pursuant to the standards of Senate Bill 391 and 644. Our community development staff will have an introduction.
Thank you very much, Chair. Let's move forward here. So the Board of County Commissioners will hear oral testimony, receive written testimony, and consider the testimony submitted at this hearing. Please note that the hearing is also being recorded. The board may make a decision on this matter today, continue the public hearing to a date certain, or leave the written record open for a specified period of time. And the hearing will be conducted in the following order. First, staff will give a report on this issue. We will then open the hearing to all present and ask people to present testimony at one of the tables or at the podium. You can also provide the board with a copy of any written testimony. Please note that this is a hybrid meeting, and if you are participating via Zoom, if you are participating in person, please be sure to fill out one of the blue sign-up sheets and submit that to the board secretary at the side of the room. You will then be called to the table to provide any testimony. For remote participants, please indicate if you would like to provide testimony by using the raise hand button in Zoom or by dialing *9 if you are participating via phone. The chair will then call on participants with hands raised to provide any testimony. Please note that any questions to and from the chair may be entertained at any time at the chair's discretion, and cross-examination of people testifying will not be allowed. However, if any person wishes to ask a question of another person during that person's testimony, please direct your question to the chair after being recognized. The chair is free to decide whether or not to ask such questions of the person testifying. Prior to the commencement of the hearing, any party may challenge the qualifications of any commissioner for conflict of interest, but this challenge must be documented with specific reasons supported by facts. Should any commissioner be challenged, that member may disqualify himself or herself, withdraw the hearing, or make a statement on the record of their capacity to hear and decide the issue. And at this time, do any members of the commission need to set forth any information that may be perceived as a conflict of interest?
So does any commissioner have anything to disclose? And if so, please state the nature of same and whether you can proceed.
I have nothing to disclose and I can proceed.
I have nothing to disclose and I can't proceed, but I did testify in support of this bill for 3 years.
You're allowed to do that. This is legislative. You could have all the bias in the world. You just can't have a conflict of interest.
Okay, just wanted to let that be known. Thank you.
And I have nothing to disclose. I have been an advocate and a proponent in the legislature also. So does any party wish to challenge any commissioner, the members of the hearings body, based on conflicts of interest? As no challenges have been presented, well, let's take a moment. Is there any raised hand feature online for that, just in case? As no challenges are presented, the hearing is now open and staff will proceed with a brief report.
Okay. First, I'd like to point out that the full record for this particular project can be found at the following webpage. You can see it as part of this presentation. You can track that down just via DeschutesCounty.gov relatively easily. With that, I'll go into the staff report. If you have any questions as I'm going through this, commissioners, feel free to stop me at any point in time. So as we pointed out, this proposal is a county-initiated effort to formally adopt provisions for rural accessory dwelling units as identified in Senate Bills 391 and 644, which have been passed over the last 2 years. I'll briefly go through the overview of each of these Senate bills. So Senate Bill 391 was passed in June of 2021, and it authorizes a county to allow an owner of a lot or parcel within a rural residential exception area to construct one single ADU subject to certain restrictions and limitations. It doesn't require a county to allow ADUs. It's a permissive Senate bill. And it also doesn't prohibit counties from imposing additional restrictions on things like outbuildings, garages, additional uses on site that might be associated with the ADU. The legislation only applies to unincorporated rural residential exception areas, and so this has no effect on the cities of Bend, Redmond, Sisters, or Levine. Senate Bill 644 was passed in May of this year, and it alters some of the previous language from Senate Bill 391, specifically regarding state wildfire mitigation efforts. Principally, it decouples the statewide wildfire hazard map from the adoption of any local rules allowing rural ADUs. So previously, prior to release of the state wildfire hazard map, which I'm sure all of you are familiar with at this point in time, counties could adopt rules, but no one would be able to construct ADUs. And this removes that particular piece of language and allows us to move forward today. There's some local interpretations from both of these Senate bills that require decision points for county decision makers, and I'll go through each of those in turn. And here's a list of all the code sections that would be altered by the proposed amendments today. I'm not going to go through each of these, but you can see it's primarily associated with either the zones that rural ADUs would be allowed in or the actual rules and implementation themselves for each of those zones. So now I'll go through some of the basic eligibility criteria. These are things that come directly out of Senate Bill 391 or 644. So these are things that the county has no discretion in changing or altering as a go below. So as I pointed out earlier, it only applies to rural residential exception areas. In Deschutes County, we have 5 zones that meet that definition. There are RR10 zone, the MUA10 zone, the SR2.5 zone, UAR10 zone, and finally the West Side Transect zone. In order to qualify for a rural ADU, parcels have to be at least 2 acres or larger, and no portion of any lot or parcel can be within a designated area of critical state concern. We only have one of those in Deschutes County. It's the Metolius River Basin, which is in the northwestern portion of the county. There are actually no rural residential exception area properties within the Metolius River Basin, and so no properties are affected by that provision. So based on this very general eligibility criteria, staff has determined there are approximately 9,470 properties that could potentially qualify for a rural ADU based on these initial standards. However, there's a big caveat here, which is there are certain limitations at either county or property specific levels that would significantly reduce that estimate. One that I've called out here is we as staff, as I'll reference later, have recommended a 5-acre minimum parcel size in the southern portion of Deschutes County, and that would reduce that potential eligibility down to about 8,600 properties, just over that. Next, I'll go through some of the selected development criteria. These are things that have some interpretive issue that county decision makers will need to weigh in. Some of the language that's called out in Senate Bill 391 is that the ADU cannot include more than 900 square feet of usable floor area. ADUs are required to be located no farther than 100 feet from the existing single-family dwelling on site. ADUs cannot be used for short-term vacation rentals. ADUs have to have what's described as adequate access for firefighting equipment, safe evacuation, and staged evacuation area. And then finally, it has to comply with any applicable state or local wastewater regulations. Unfortunately, some of these terms that are used in Senate Bill 391 are undefined, and they've been left open to counties to interpret as they see fit. Specifically, usable floor area is undefined within the Senate bill. Senate Bill 391 also doesn't state whether that 100-foot sighting distance should apply to the entirety of a structure that's built or only a portion of said structure. It also allows jurisdictions to impose different minimum acreage standards beyond 2 acres. So counties cannot go below the 2-acre standard, but again, they can impose additional restrictions if they see fit to require greater acreage standards. And then finally, it does not identify or define or vet things like adequate access for firefighting equipment, safe evacuation, or staged evacuation areas. So these are all things that we as staff have tried to come up with what we think are reasonable definitions. So the first of these, usable floor area, we've currently defined as the area of the ADU that's included within the surrounding insulated exterior walls, but exclusive of things like garages, carports, decks, and porch covers. So this is intended to capture the fact that there is a living area associated with the ADU, but potentially could be allowed accessory components for things like storage, parking of vehicles, et cetera. The next interpretive issue that we've weighed in on is the 100-foot sighting distance, and we've defined that as the ADU has to be located no farther than 100 feet from the single-family dwelling, as we pointed out, but only measured from the nearest portion of the usable floor area to the primary dwelling. So we're saying that the entirety of the ADU doesn't necessarily have to meet the 100-foot sighting distance standard, but at least some portion of the living space does. Adequate access, this will get a little bit complicated, so bear with me. As we pointed out, the Senate bill requires that adequate access to firefighting equipment be provided. We've defined staged evacuation areas, which is another undefined term, as a public or private location that occupants of the ADU may evacuate to reorganize following some type of disaster event. A safe evacuation plan in this case, we've defined as an identifiable route on rights of way and any on-site driveways from the ADU to your staged evacuation area. And then finally, adequate access requirements we've had to alter since the initial draft to establish more clear and objective standard. So as the board, part of the board's package today, you'll see our newest version of that draft. And we've taken language based on the Deschutes County Code Title 17 standards. Those are our subdivision and partition ordinance standards, some definitions from the road department, and some general road access standards that were given to us by multiple fire protection service providers. So we felt that that sort of blend of all those definitions was probably useful in getting at what would be appropriate adequate access across multiple parties. With that said, we've determined that adequate access in this case could be demonstrated in 2 possible ways. We have a set of prescriptive standards that are based on those definitions that I just called out. They're essentially a set of dimension standards for roads, what roads can be composed of, vegetation clearance along said rights of way or any on-site driveways, or as a secondary standard, if a property owner is able to provide written confirmation from their fire protection service provider that they do have adequate access to the property that meets their minimum standards or requirements, that can also serve as adequate access in place of the first standard. So what does this look like in practice, or what do we think it would look like in practice? As part of an application for an ADU, the applicant would provide both verification that there is adequate access to the ADU as defined in the code. They would have to provide a safe evacuation plan, which is again that identifiable route on rights of way and driveways to their safe evacuation point. And then finally, they'd have to provide written authorization from whoever the owner of the staged evacuation area is that occupants of the ADU can evacuate to that place should they need.
So just a kind of understanding the terminology here a little bit. So written authorization from the owner of the staged evacuation area. When I think of the scenario here, I'm thinking, primary dwelling, and if there was a secondary dwelling, being clear access to a public road, a public access road would mean that Deschutes County would be the authority there. I'm just envisioning, a couple acre property where you need to go from point A to point B, and point A is your house, to a public road or, right of way, maintained or not, I guess is what I'm stumbling on there a little bit.
Correct. Yeah. So rights of way in this case, we're relying on the currently existing Deschutes County definition of right of way, which is a set of standards. Either, I think it's three possible options. It's either a road, a right of way that the county has ownership and maintenance responsibilities for. It's either an unmaintained road. That's the last option, or there's a middle option, which is it's not controlled by the county, but there's maintenance responsibilities from some secondary party.
So, a square property on a public road, it'd be pretty clear, but there's some properties that have flag lots, or, you're getting around somebody else's property to get to your property. So there may be some interesting scenarios in there.
Correct. Yeah. This was, again, as I pointed out, it's relatively complicated. And this was, we thought our best guess of allowing people to rely on existing rights of way primarily, and likely many existing on-site driveways, but to still meet what we thought was the spirit of the bill in providing safe access for firefighters and fire protection service officials.
Thank you.
Of course. Regarding wildlife resources, so to the extent that Oregon's statewide planning goal 5, which deals with natural resources, including wildlife resources, staff has provided findings that address ADUs as a conflicting use in areas designated as a goal 5 resource in Deschutes County. In our county, primarily we're focused on goal 5 resources that are overlaid with a wildlife area combining zone. We have 3 wildlife area combining zones in the county that would be affected by this proposal. That's our deer winter range, our deer migration range, and then our elk range. And because our zoning codes are being amended to allow ADUs as a possible conflicting use, they're subject, we believe, to an economic, social, and environmental and energy, or EASY analysis. That's been included again as part of staff's findings, and it's within the board's packet today. These EASY analysis, just for general information, they're not intended as a formal legislative item. It's really more of a decision-making tool for the commissioners at large to determine how to balance these issues in goal 5 areas if they desire to at all. Next piece I'll talk about is wildfire mitigation and the standards of the Senate bills, as well as some of our local efforts. So as I pointed out previously, no properties under the language of Senate Bill 391 would have been eligible for construction of a rural ADU until the new iteration of the state wildfire hazard map was released by the Oregon Department of Forestry. However, Senate Bill 644 was passed and it removed that particular requirement. However, in place of that standard where the maps needed to be released, rural ADUs can now be permitted, but they're required to be constructed to R327 standards of the Oregon Residential Specialty Code. These are fire hardening requirements related to residential building construction. So they deal with things like the types of roof materials, type of siding materials, screening, venting, all of the relevant features that you would put in place on a home to have it not subject to fire ignition.
One of the conclusions I came to, these are probably not going to be 2-story homes with a upper deck or anything much more complicated than a single story roof line, I guess. So it's just an observation, studying and thinking through this. So 900 square feet probably isn't going to promote 2-story structures. Maybe it would, but I'm just acknowledging that for people following.
Yeah. Our draft amendments now include these provisions that reference those R327 standards, and both before and after release of the map. So there's kind of a set of language in there that once the map is ultimately released, it reverts back to the initial rules, wherein properties that are subject to the state standards regarding wildfire mitigation are put in place after the map's released, but before all ADUs that are constructed have to meet these additional requirements. Senate Bill 644 doesn't address defensible space standards for ADUs that are developed prior to release of the statewide hazard map. And given this lack of information from the state level, we elected with county legal counsel to craft some supplemental defensible space rules for any ADU development which does occur prior to adoption and release of the hazard map. And those standards are based on existing rules within the forest use zone. And ultimately, they'd be removed after final adoption of the state hazard map, wherein, again, state rules regarding defensible space would be put in place. These defensible space rules are very similar to the adequate assets piece in that there are two possible standards. We have prescriptive rules, which are, again, based on our existing forest use zone standards, or if you're able to develop a plan in consultation with your local fire service protection provider, and they agree that you've met whatever the defensible space requirements are, that would serve to meet the standard as well. The next, I'll go through some of the agency comments that we've received in regards to this proposal. The first set of comments is directed from our on-site wastewater division or our environmental soils division. And they note specifically that wastewater infrastructure is specifically, in most cases, only sized to a single dwelling, and a majority of properties that are hoping to develop ADUs will likely require upgrades, expansions, or entirely separate systems to serve ADUs. They note primarily that certain sites may not be suitable for ADUs because of items like soils, setbacks, or other site limiting factors. The next piece that they wanted to point out was in Southern Deschutes County, a number of agencies, including the U.S. Geological Society or Survey, the Oregon Department of Environmental Quality and Deschutes County have studied Southern Deschutes County extensively. And DEQ in particular has determined that water resources are already at risk of contamination from on-site wastewater systems. This is a longstanding issue in Deschutes County. The board's familiar with some of the issues down there. They point out that increasing the density and the number of dwellings in the area will increase loading of nitrates that in some cases are already exceeding sustainable nitrate loading standards. Given those concerns, they recommend that larger parcel sizes of 5 acres should be utilized in Southern Deschutes County in order to qualify for an ADU. As I pointed out earlier, this recommendation has already been included in staff's draft amendments. And the boundaries of where those new standards would apply are defined via the Upper Deschutes watershed area studied during the Lapine demonstration project from 2007. That was a joint effort with the U.S. Geological Survey. Next agency comments I'll point out come from the Oregon Department of Fish and Wildlife. They had some general concerns that allowing rural ADUs would potentially constitute a conflicting use for wildlife populations and habitat. And given those concerns, they specifically request that the siting and fencing standards of Deschutes County's current wildlife area combining zone be applicable to rural ADU development. Staff believes that these standards would likely apply anyway without any additional language being added into our code, because it does apply to all new dwellings, which in this case we believe would obviously apply to ADUs as well. They also requested that some sizing or dimensional limitations be applied for non-livable space associated with an ADU. So these might be things like accessory components, detached garage or an attached garage, non-livable space portions of an ADU that might be developed. And then finally, they requested that access to ADUs utilize existing roads and driveways. Next piece of comments from agencies is from our fire protection districts. To date, we've only had one fire protection district weigh in definitively on the proposed amendments. That was Lapine Rural Fire. And they specifically pointed out that the Oregon Forest Land Urban Interface Fire Protection Standards need to be maintained for any rural ADU development, and that all Oregon State fire codes need to be maintained, including access and water supply standards. We believe that generally these would broadly apply in the same way that they would for any type of residential development. Finally, they pointed out that when it becomes applicable, the county should fully adopt and implement the state's new structural wildland urban interface hardening codes. Those come from Senate Bill 762, which was also passed in 2021. and that any new accessory dwelling unit be fire sprinklered. Next piece of comments is from the Oregon Water Resources Department. A lot of these were in relation to public comments that were submitted, given concerns around well impacts that might be associated with increasing residential density in certain areas. And they point out specifically that under Oregon law, a landowner is able to drill a well and use that well for certain exempt uses that are found in the Oregon revised statutes. Those are specific for residential purposes, so drinking water, certain amounts of irrigation for things like lawns or gardens, and that those are exempt uses up to a certain amount of water being extracted every day. However, landowners are not allowed to drill 2 exempt wells on a piece of property and then double the number of exempt uses. That would include, in this case, for the establishment of an ADU. So even if you construct a rural ADU, Oregon state law would not allow you to have double the amount of exempt water uses for residential purposes. They point out that the recent decline in the water table in Deschutes County is due primarily to 3 causes in their estimation. The most significant is that in the last 20 years, it's been much drier than average, and there's been decreased recharge of the Cascade Range to the aquifer. The second reason being the increase in the number of uses in the basin of all kinds has led to the lowering of water table. So this includes agricultural uses, residential uses, industrial uses, et cetera. And then third and least significant is the lining and piping of irrigation district canals in the region. Finally, they point out that private well use under the exempt uses in the entire basin is approximately 6,000 acre feet of water annually. And to put that in perspective, the average annual basin recharge is around 2.5 million acre feet annually. They're pointing out essentially that domestic use makes up a very small fraction of overall water consumption in our region. Within our draft code language, I'll point out that we've included some of this directly from Senate Bill 391, and it specifically calls out that ADUs do not constitute another use which might double exempt water uses on an individual property. This isn't specifically a standard that we would enforce, given that Deschutes County Planning or Building Safety doesn't have regulatory authority over water use, but this is more of a disclaimer for parties that might be hoping to build an ADU, that even if you drill another well, you're still limited by the initial first exempt water right that you acquired for a piece of property.
So Kyle, does following the comments from Oregon Water Resources Department, would they essentially want the property owner to abandon the first well if they do drill a second one? I mean, or is that?
Yeah, I think that's best practice. They didn't go quite that far. I think they would prefer property owners to do that. But if a property owner had a specific set of circumstances where they needed to drill a second well, maybe the first well was not deep enough and it was too expensive to try to deepen that well, whatever it happened to be, then they left open the possibility that property owners might do this. Okay. But just general best practices, I think they would prefer in most cases that property owners rely on a single well where possible.
But the exempt use threshold
remains the same.
Okay, for the 2 units, even though.
Correct. So whether you have 1 well, 2 wells, 3 wells, whatever it happens to be, you're still limited by the exempt use standard, which is, I believe, about 15,000 gallons, something like that per day. Yeah.
With no measurement and no monitoring. So it's okay.
To Commissioner Chang's point here, so OWRD does believe that limiting the number of wells on a parcel of land is best practice, although they've stopped short of recommending that we include that in code, particularly given that, as I pointed out earlier, Deschutes County, we don't have jurisdiction in regulating Oregon water law. The primary reason that they think that limiting the number of wells is good practice is to avoid contamination possibilities. So if you have multiple access points to the aquifer, the chances of that aquifer being contaminated by surface actions is increased. Senate Bill 391 does allow jurisdictions to require that ADUs be served by the same water supply. That isn't currently in the draft amendments, although that obviously could be added if the commissioners wished. So that there would be a new standard in place that if you were to construct an ADU, you'd have to use a single existing well on site rather than possibly unlimited number of wells. Finally, just to reiterate here, so everyone's clear, water rights and well permitting, however, are areas and issues that are overseen by OWRD. So we don't have the ability to regulate water rights. Next and last set of comments that I'll point out come from water utilities in the region. They've specifically requested that what we describe as will serve letters or willing and able to serve letters be provided by applicants of an ADU if it's to be served by any water source other than an on-site domestic well. Their primary reason for this request is they don't want to see additional development occur in places where they might not have infrastructure in place to sufficiently provide water to these new uses that would come online. And so it's really a planning mechanism to ensure that if they believe 5 more dwelling units are going to be established, that they actually have the capacity to serve those uses. And so based on that request, we've included that specific standard in our draft amendments. Next, I'll go through some of the public comments that we've received to date. So far, we've received 24 written comments that are addressing the proposed amendment, although some of those comments are duplicate submissions from the same party. 12 of those comments, I should say 12, have submitted support generally. They're citing general benefits of increasing the housing supply in the region, the increased opportunities for intergenerational living opportunities, and overall increased economic activity that would result from rural ADU development. In contrast, 12 of the comments, so it's pretty much a split opinion here, have expressed general opposition to the proposal, citing traffic increases, impacts to water and wildlife resources, increased wildfire risk associated with additional development, skepticism around impacts to housing affordability that might be associated with rural ADU development, and the general loss of open space and the rural character associated with unincorporated Deschutes County. Some of these commenters I'll point out of those that expressed opposition requested a full denial, while others simply wanted additional regulatory standards to reduce whatever these impacts might be that they could see coming from additional development, residential development in the unincorporated county. Next, I'll go to our Planning Commission actions. So a public hearing on these amendments was held before the Deschutes County Planning Commission on September 22nd of last year. During the public hearing, we had 9 individuals provide testimony. And again, testimony was generally split between parties that were opposed or supportive of the proposed amendments. The commission ultimately held deliberations on October 27th, 2022, and provided recommendations to the board. However, given the passage of Senate Bill 644, staff was required to alter our previously recommended draft amendments, and a new iteration of the commission ultimately reviewed the new version of those amendments on July 13th of this year and provided some new and/or supplemental recommendations to the board. Next, I'll go through each of those recommendations in turn from both of their respective iterations of the Planning Commission. So ultimately, the commission recommended adoption of the proposed amendments, however, with significant alterations. The initial recommendation was approved by a vote of 4-2, while the second recommendation was approved by a vote of 5-0. The first commission specifically recommended that usable floor area be defined not only as the area of the accessory dwelling unit included within the surrounding exterior walls, but also including garages and other accessory components. So to put this in perspective, rather than staff's initial draft amendments, this would mean that you get a 900 square foot structure that would include garages, your living space, whatever it happens to be, and that would be the overall limitation on accessory dwelling units. This recommendation was primarily made given that there were no other limitations put in place on accessory structures, And it wasn't clear what impacts that would have should property owners begin developing large accessory components of ADUs and what that might lead to in the future. Ultimately, that first recommendation was approved by a vote of 5-1. The second commission, however, recommended that usable floor area be defined as staff initially recommended. Again, that would mean the 900 square foot usable floor area would not include items like accessory components of attached garages, storage areas, things of that nature. Because that proposal was unchanged from staff's recommendation, there wasn't an approval vote taken on that particular issue. In regards to siting distance, both iterations of the commission found that staff's initial draft recommendation for how to determine or define that should be held in place, which is again, given that ADUs have to be within 100 feet of a primary dwelling on site, that measurement should begin from the nearest portion of the usable floor area to the single family dwelling. The next issue related to groundwater issues in South County. As I pointed out earlier, staff recommended, based on feedback from our environmental soils division, that the minimum parcel size in southern Deschutes County be at least 5 acres, given those concerns around nitrate loading and additional increases in wastewater systems. And that recommendation both times was unchanged from staff's initial proposal, and so no votes were taken. Regarding wildlife areas, the first iteration of the commission recommended prohibiting rural ADU development in our designated Goal 5 resource areas. That would include our wildlife area combining zone, our greater sage grouse area combining zone, and the sensitive bird and mammal habitat combining zone. The primary effect of this would really be the wildlife area combining zone. That's the kind of meat of this, where based on this recommendation, rural ADUs would not be allowed. And that would shrink the overall number down from that initial roughly 8,600 estimate. I can't remember the final numbers, but I can certainly pull it up at some point if the commissioners have questions. That initial recommendation was approved by a vote of 5-1. The second iteration of the commission also recommended prohibiting rural ADU development in those designated Goal 5 resource areas. However, that particular vote was a little bit slimmer. It was approved by a vote of 3-2. Regarding Senate Bill 762 and the state wildfire mitigation standards, the first iteration of the commission initially recommended delaying the adoption of any of our local ADU rules until such time as the state wildfire hazard map was ultimately released by the Department of Forestry. That was approved by a vote of 6-0. However, as we've talked about a few times here, pursuant to Senate Bill 644, staff finds that it's possible this previous recommendation is no longer applicable, given that we have interim standards in place that specifically address wildfire mitigation in the development of ADUs. Next recommendation is in relation to the West Side Transect Zone. For the commissioners and the public's benefit, the Transect Zone is a recently established zone on the western edge of the city of Bend. It was essentially a piece of compromise legislation to allow some additional, more dense development on the western edge of Bend, but preserve natural habitat areas and create wildfire mitigation buffers to provide as kind of a feathering of development out into some of our natural areas on the western edge of the city. That was ultimately approved by the first commission in a vote of 6-0. The second iteration of the commission also recommended prohibiting ADU development in the West Side Transect Zone for very similar reasons as the first, although that was ultimately approved only by a vote of 3-2. And then the last piece I'll talk about here relates to vacation occupancy. So as I pointed out earlier, the standards of Senate Bill 391 and 644 prohibit any ADUs that are constructed from being utilized for vacation occupancy. There's 3 sets of standards and how they define vacation occupancy. A lot of it has to do with, is it your primary residence and the number of days that you're staying in whatever the unit is. So if you're staying for less than 45 days and it's not your primary residence, under state standards, it constitutes a vacation occupancy. However, the first given a lot of concerns regarding this standard, the first iteration of the commission recommended that both the primary residence that's established on site, as well as an accessory dwelling unit, be prohibited from vacation occupancy use if a property owner elects to construct a rural ADU on site. That was ultimately approved by a vote of 6-0. The second iteration of the commission also recommended prohibiting both the primary single-family dwelling and the ADU for occupancy use for very similar reasons. That was ultimately approved by a vote of 4-0 with one commissioner abstaining. And then some general discussion points that were brought up by the first iteration of the commission. They expressed some concern that rural ADU amendments were being presented prior to completion of other long-range planning initiatives, which they thought might affect the proposal broadly, and specifically pointing out the wildfire mitigation efforts and Senate Bill 762 mapping standards, as well as the Deschutes County Comprehensive Plan update, or Deschutes 2040, which is currently underway. Some next steps for the board to consider here. You have a couple options moving forward. You can continue the hearing to a date and time certain after you've taken your public testimony and answered any questions from staff. You can close the hearing and leave the written record open to a date certain. You can close the hearing and set a specific date for deliberations, or you can close the hearing and commence deliberations today. And with that, I'll open it up to any questions.
Thank you very much. Very comprehensive. I want to thank the Planning Commission for reviewing this and kind of taking a big picture look at it. It is a very mature package, and for everybody that just followed that, you know, the issues are definitely broken down for all of us to see. So any questions or thoughts?
Kyle, I wanted to ask about the goal 5 wildlife recommendations from the Planning Commission. I very much appreciate the desire to preserve habitat connectivity, reduce, prohibit fragmentation. At the same time, I am not sure whether, like an outright prohibition on rural ADUs within the combined wildlife overlay zone, A, will achieve the desired results, or B, be particularly significant, for wildlife and for, fragmentation concerns. It's my understanding that within our existing wildlife overlay zone, property owners, the property owners we're talking about are allowed to build not necessarily ADUs, but all kinds of other accessory buildings already. So, if you've got two out garages on your primary residence, that the amount of fragmentation on the landscape is significant, for an accessory building is already there. So rather than having two accessory garages, you got one ADU and one accessory garage. I don't see a lot of difference between that. So I'm wondering if we did not want to go all the way to the Planning Commission's recommendation of outright prohibiting ADUs in the wildlife combining zone. What could we do? ODF&W made some recommendations to us. In our staff memo, it kind of broke those down and explained how complicated some of those might be. But what are things that we could do to allow rural ADUs in the wildlife combining zone while taking additional special measures to reduce the fragmentation, and the impacts on habitat?
That's a great question. I think in some respects, I would probably refer you back to what the recommendations from the Department of Fish and Wildlife were. The primary one being, as I pointed out in my presentation, they recommended possible sizing limitations or square footage limitations for accessory components. So rather than leaving that open-ended, putting a number on whatever your usable floor area is, you have the 900 square feet there, but then you could add an additional number onto that. I will point out that, at least as staff thinking about implementing these from kind of people walking up to our planning counter and how we would review these, it becomes a good bit more complicated in practice. When you're talking about what constitutes an accessory component, how do you figure out which sections of accessory buildings might be associated with an ADU versus the primary dwelling or any other use that's afforded to a particular piece of property. So it's not impossible to do something like that. And that's obviously an option that the board could consider. But it would likely require additional effort on our part, both to coordinate with experts to see what is the right numbers if you wanted to go that far, and then additional efforts in place to make sure that any applicants would understand what those requirements are and how we would evaluate those, which is those more nuanced issues kind of go away if you just have it's a 900 square foot usable floor area and then everything else is kind of left open-ended.
And then to make it even more complicated, I wanted to also ask whether it was possible to relate the ADU to other accessory building opportunities. So, you can have your primary, you can have a detached garage, one detached garage, only one, and then you can have your ADU with a certain amount of garage or carport or storage space connected to that ADU. I mean, speaking to the concern you were just expressing, that makes it even harder for our planners to communicate the uniqueness of doing an ADU within the overlay zone. But are we allowed to do that?
You technically, yes, the board, this is up to your discretion. I mean, outside of superseding what the state standards are, you can put any requirements you want in place here, provided that you're meeting whatever state law is. I will point out this is more of an aside that addresses maybe some of your concerns. Is we have at least at a few times in the past, if a property owner were to develop, let's say, multiple accessory structures on their property, and it isn't clear if it's no longer subordinate to whatever the primary use of the property is. So let's say a dwelling unit, a residential use of the property. So if you build a 20,000 square foot garage, at least to staff's mind, and ultimately this is something we'd likely refer to a hearing, it becomes less clear how that's still subordinate to the residential use of the property if you have what is starting to look like a full scale, whatever it is in this very large building on site.
Auto shop or something.
Yeah,
like that.
exactly.
Yeah.
Jay Leno's other garage.
Yeah. That is a relatively rare set of circumstances, but it has come up in the past. And ultimately, like I said, in those instances, if they did arise, we'd likely refer it to a hearings officer and they would interpret our code for us and provide recommendations, which the board could weigh in at some point as well.
So Kyle, today, could somebody build a 20,000 square foot garage?
Technically, yes.
They could. Okay.
Okay, so this is a public hearing on the matter. Thank you very much for that comprehensive overview. So there's opportunity to testify in this matter. Please fill out a blue form. Also, if anybody's online, we have one request are there any other agency comments? Just anybody in the room or following right now for agencies? So this is a legislative matter. So at this time, we'll just go to comment. So Tyler Neese. Thank you for joining us.
Yeah. Thank you for the opportunity. Good morning, Chair and Commissioners. My name is Tyler Neese. I'm the Government Affairs Director with the Central Oregon Association of Realtors. And on behalf of the organization, thank you for the opportunity to comment on the proposed legislative amendments. We've submitted comments and provided testimony previously on this issue, and I'm here today just to reiterate our support for permitting ADUs in the rural county as allowed by Senate Bill 391. The county and its staff, as you know, have been leading in both the development and advocating for the allowance of rural ADUs throughout multiple sessions of the legislature, and we appreciate all your efforts. We encourage you to continue to be a leader on this issue. We believe the ADUs offer another affordable housing option and some diversity of housing stock in an environment in which that's very badly needed. As you heard in the staff report, there are some areas of Senate Bill 391 and Senate Bill 644 that are still unclear. Senate Bill 391 also did not address existing illegal ADUs. We encourage the board to consider as part of its legislative agenda moving forward, providing feedback to the legislature and basically providing a path forward for those type of ADUs that may not meet the criteria laid out by Senate Bill 391. As you know, there's no flexibility in that bill, but we believe that especially from a fire safety standpoint, it is in the best interest of all that these existing ADUs have some sort of path to come on the books if certain criteria are met. So we ask you to consider that as part of your efforts with the legislature moving forward. And with that, just thank you for your time and your consideration, as well as your service to Deschutes County. Thank you.
Thank you.
Thanks, Tyler.
So that was our one request to speak on this topic today. Is there anybody else? Please do. Yes. Yep, not a problem. You can, yep. I'll be able to introduce you. So Katie Kramer, thank you for joining us.
All right, I guess I just wanted to put a face to this issue a little bit. So my name's Katie. I was born and raised in Bend, Oregon. I've lived in the same house my entire life. I graduated from Oregon State Cascades with a natural resource degree. I lost my mom 4 years ago this month, and then my dad had to sell the house. So I bought a tiny house, and this seemed like the best option for me at the time. I have a dog, a wonderful boyfriend with me. This just seemed like the best option. So I went down to the county after I bought this house 2 years ago, and I was laughed at because there was no way to get this tiny house legally on land. I have one family member left in Bend. She's in RR10, and she would like me at the property, and that would be ideal. I work a full-time job for Deschutes National Forest. I'm a firefighter type 2. So I know everything about the wildlife, fire considerations. And I think this just would be the best option if I could have a plan moving forward. It's a great option for houselessness in this area. I mean, I don't want to park it in China Hat. So I'm just trying to do this in a legal manner that would be the best living option in my circumstances, in our circumstances. So I was born and raised in Bend, and I would really like to stay here. And I bought and owned my tiny house. I paid it out in full. And yeah, if we could just get legislation moving forward to define tiny houses, and this rural ADU would really help a lot of people out.
Katie, I'm not sure how the rural ADU legislation and the land use process we're setting in place for rural ADUs would affect tiny houses, but I did want to bring to your attention that the legislature just this session that ended a few weeks ago passed a bill, House Bill 1013, which is going to allow rural property owners to host an RV, one RV on their property for residential purposes. So it's possible because if your tiny house is on wheels, it's possible that your tiny house would be classified more as an RV than as an ADU. So House Bill 1013 might create that opportunity for your family member with the RR10 property to host your RV. Community development staff would have a better sense of when we're going to be doing the process, doing the rules, essentially the local rules to allow that use to go forward. But it's something I'm thinking you should, it would be good for you to check out. And I mean, there's Kyle, but in the audience also there's our planning director Will Groves and our community development director Peter Gutowski are back there as well to ask about that.
Thank you.
Yeah, thank you very much for your testimony. And as I say, it's kind of a new generation of what's possible and what's needed out there. So you are a great example of that. So thank you very much for providing testimony.
Yes. Thanks, Katie.
So it looks like we'll have a slow roll for public testimony today, but next. Yes. Great. Yep, that's fine. Thank you.
Nancy
So
Grolke.
So Nancy Gulke, thank you very much for joining us.
The codification doesn't clarify changing existing buildings to an ADU that meet all the other criteria. Two, I'm surprised that this commission is addressing wildlife corridors when the new development along Stevens and Ward have already affected an increase in owls and raccoons and foxes and other raptors onto our farm from the land already being disturbed. The use of ADUs is different. I think it's already been addressed. Use of ADUs is different from sheds and barns because of the use and additional human factors which are affecting wildlife in a different way than barns and sheds or industrial uses for that matter that you've addressed. And also I want to point out that the wildfire hazard map is highly flawed and has not been vetted properly. So expect that to change in the future. The guy who developed the model for it was one of my employees, and I sent him to Montana. So, and I haven't written my letters to Oregon Department of Forestry, but I'm intending to talk to the new guy. So, thanks.
Great, thank you. Well, just some words along those lines for wildfire threat here in Deschutes County. We did a mapping project, and there's some history of Deschutes County's analysis of wildfire threat and mapping. And it comes down to the fact that you could see an ember shower from a fire activity, half mile from a fire, pretty much anywhere in the county. Some are treat areas, some are grassy areas, but a hot, dry, windy day. So then that conclusion is that basically the whole county is a high risk of some sort. And it's all about terminology, high or extreme or the terminology.
Kyle, could you speak to Nancy's question about existing buildings, kind of taking an existing accessory building and turning it into, retrofitting it to a rural ADU? What does that process look like?
I think in this case, it would look exactly the same as constructing a new ADU. So we haven't called, I'll speak to two items here. One that was specifically brought up by our current planning staff that we wanted to highlight directly were those instances where someone were to build their ADU first, for example, and then they wanted to convert that into their primary residence, if that makes sense, so that you didn't necessarily have to build your dream home first. You could build the ADU first and then subsequently build that and convert it. So we expressly called that out in the draft language here. In terms of converting an existing building, while we haven't called that out directly, provided that they met all the requirements here, there's nothing that would disallow a property owner from doing that.
And
it would obviously have to go through the normal permitting process to ensure that it was actually permitted as a dwelling, and it would have to meet all the standards of Senate Bill 391 and the local code. But again, nothing that would disallow it.
Kyle, Tyler brought up the illegal ADUs that are in the county. And I know that that's a big worry for a lot of people that do have them. And it is workforce housing. So if they are within the 100 feet, a corner of that structure, then they could actually apply and be converted when we do take care of this amendment.
Again, yeah. So provided that whatever the structure is met all of the standards of the Senate bills as well as the local code, and it were permitted as a dwelling. So you'd have to, assuming the structure was not previously built as a dwelling and reviewed as such, they would have to go talk to the Deschutes County Building Safety Division to make sure that all the proper inspections were done and that it was ultimately permitted as a dwelling. But again, provided they can meet all of those requirements, then yes, they could convert something like an existing structure into a rural ADU.
So as long as a corner of that structure was within 100 feet.
As long as a portion of the usable floor area as currently defined, yeah. Unless that definition were to change, obviously.
So this is a public hearing on the matter. Is there anybody wishing to speak on this? Is there anybody online? We have a raised hand feature. Good. It's wonderful when it works. Well, and it does. I mean, the technology is here. So we're seeing NMG on the screen. Please introduce yourself.
Hi, my name's Nona. Can you hear me?
Yes, we can.
Hi, thank you for this hearing. I keep hearing the 100-foot requirement, and I'm just wondering if there's like any discretion from the planning department to for a variance on that 100 feet to convert an existing accessory structure. I mean, it might be 150, it might be 200. I haven't measured it, but I'm thinking, I mean, the whole reason I want to convert it is so I could keep my property, you know, with the increased cost. My insurance was canceled, my rate tripled. I mean, with inflation, it would be cost prohibitive to build a new structure, and it's a 10-acre property. And, I think it meets all the other criteria. It's in a homeowners association. We're a Firewise community. I have deer and elk and other wildlife just running around, and it's already clustered. I'm just wondering if there is ever an opportunity for a variance. I mean, it just is common sense. That's one question. And then the other one is where can I go to? Is there a link to the requirements for on-site wastewater? The other main dwelling is tiny. I mean, there would be a total of 2 people living on the entire structure. I don't think it would overload the current septic system, but I'd like to know what the regulations are. I also wanted to counter the people who object to this ordinance because of all the reasons they mentioned: traffic, impacts to wildlife, all fire danger. There are a lot of ADUs out there that are just not permitted, and I just think this is not going to increase the amount of ADUs. I've seen studies from other municipalities, and I just think all it's going to do is decriminalize and codify structures that are already in use. So I'd like to submit that for the record. I think that's it.
Great. Thank you very much for your testimony.
Okay, thank you.
We should probably say the legislation, Senate Bill 391, that provided this new development opportunity for rural residents of Oregon specified 100 feet. So what our hands are at the county level, at least our hands are tied on that. I think the only way you get that kind of an exception is if you ask state legislators to go back and modify the 100 foot limitation.
Yeah, I wonder. Yeah, I don't know the reasoning behind that. I mean, I just wondered what the reasoning is. I don't know that it would make any difference if it was 150 feet in my case on 10 acres. But one thought that came to me was that the existing home does not have a garage. So I thought, well, I could add a cheap garage on the corner of the house so that I was within 100 feet. I mean, it's just ridiculous. You know what I mean? It's like, would that work?
Possibly.
Kyle, would that work?
I think
You see an application probably.
Yeah, I think in this particular case, we would interpret this, and I think the goal of Senate Bill 391 was for a separate structure. It doesn't actually go into that level of detail of how you might deal with what amounts to a duplex is basically what I think the commenter is talking about here.
No, they're
I think the
separate.
commenter.
Garage to the existing house.
Primary dwelling.
Garage is close to.
I see.
you could add a garage that got you 50 feet closer.
Yes, technically, I think, yeah, you, under the current rules, at least as
Well-
we drafted them.
So
Don't
that's
spread
the
it
public
around.
hearing on the matter. Let's not go down this path too far here.
Okay.
One
I
one
just-
last statement.
Okay.
Oh, no.
Oh,
But
no, that's
it is a novel idea because,
Well,
you know,
and there's variables all around this.
I would say, I mean, without knowing, this is all very hypothetical. So I would say under that, there's nothing that's specifically written into the code that would disallow that. My assumption is that we would likely send some proposal that attempted to do that to a hearings officer to have them interpret our.
Yeah,
make a
so it's
decision.
undetermined.
Talking about a specific land use application and
Yeah.
you can come in and talk with the community development department about that.
Thank you.
Thank you for your testimony. Okay, anyone else? Please join us. Counselor, please come to the table. Yep, and introduce yourself. And we know who you are, but yeah, Counselor Evelyn.
My name is Clifford Evelyn. I'm the city councilor in Redmond, Oregon. I just had a simple question. So for these unpermitted ADUs that's in place now, what is the criteria of holding those people accountable and making them come up and meet, match whatever criteria that it is? How do we do that? Because one of the things that I found living in Central Oregon is code enforcement doesn't seem as strong as it should be. There's numerous things that's going on in Redmond. I'm gonna bring Redmond, that's where I live at. I see I'm an advocate for the homeless and trying to help the homeless. But there's people are just putting up structures on their land. They're making it like auto repair shops and things like that. And I'll use my house for an example. I bought my house based on the area around it. And my wife and I looked at it and we said, yeah, this is a nice area, looks good, let's get it. So we brought it. And now I got a guy next door to me, it's like Sanford and Son. I mean, he got tires, everything. Anything you could find on there in addition to bringing wood trucks to come hang out for a while. So I guess my question is, what criteria is going to be in place? Eric, Kyle? Kyle gave us some very specific guidelines, but how do you enforce those guidelines? Because right now, I think they're just going astray.
Thank you very much. That's a question to the board here, and we could go for a while on that one. There's an existing code enforcement system in Deschutes County and each jurisdiction, like the city of Redmond.
It's a homework assignment.
Homework assignment. There we go.
And we don't want to send people the message that they can build first and then ask permission
Yep.
later.
That's very much it.
But it's, some of it has already happened.
So there's a good body of knowledge on that. I'm hesitant to go much deeper into that right now, but homework assignment was mentioned. So as I say, anyone else on the public hearing? So seeing none, at this time, is it a will of the board to close the public hearing? So we're going to take some steps here. Also, I just wanted to note, I want to acknowledge that we had this down for about a half hour. We're already working our way past that, but we can figure out where we're going to go today, and just acknowledging for the other items coming up. Thoughts?
Besides ADUs in the combined wildlife overlay zone, I'm pretty supportive of the planning commission's recommendations, and I'd be ready to deliberate right
Yeah,
now.
so closing public hearing is the step I'm talking about now, and then possible getting right to deliberations, Commissioner.
I know that we've actually been hearing from a lot of people from South County. And our staff is clearly supports the idea that they need to be on 5 acres, and yet South County is so desperate for more housing. And I don't know, there may be some more people in South County that really do want to send in a letter. So I'm not sure about deliberating today, but could we do it in 2 weeks?
Well, so I'm supportive of closing the public hearing.
Right, close that, but
We have heard from different folks. We might hear from some more. It's a legislative matter. So what happens if we have input between now and a set deliberation time?
That's appropriate.
Yeah, so it's, let's set a deliberation time. So then you're supportive of, if somebody else wants to share information, that's fine also.
Yeah, you would typically
Keep the
have the
written
record,
record open.
you would typically have the record closed at the date and time set for deliberations.
Okay,
So it's 9 o'clock, 2 weeks from today, that's when the record closed on a legislative matter.
there we go. So that fits right, that scenario real well. And as I say, we're not having a board meeting next week. Monday afternoon has been canceled. Wednesday's the fair. So it is going to be 2 weeks before we get back to any item. So we're supportive of that, it looks like. So closing the oral record and leaving the written record open, setting a date and time for deliberations on this matter. It's very exciting, the opportunity that's here. And we'll say more when we deliberate.
If some of those folks from South County are watching, I do want to emphasize that the 5-acre constraint that's being proposed and the wildlife inventory, the combined wildlife overlay area constraints are separate. And the 5-acre size limit in South County, or the 5-acre threshold, is being proposed to protect groundwater quality. It's not about habitat.
But the habitat recommendation for a wildlife overlay is all of South County.
Yes.
So it's acknowledging
Yeah.
one is an on-off switch for basically the whole thing. The other one limits to certain sizes.
But there were, in some of the comments we were getting, I think that there was confusion about the way that those two things came together, and people thought that the wildlife overlay was causing a 5-acre size threshold, and that's the 5-acre size threshold is about groundwater quality protection.
So I guess just from our other commissioners, if we wanted to take time, I think we could deliberate down to a couple items today, maybe not finish it also, which means taking more time on this topic, setting a little bit more direction to it. It's just, kind of, if we're supportive of starting deliberations, I could almost get there is my point.
I mean, if we,
Caution, if you're going to hold the record open, it's generally not a good idea to do that.
Oh, I was just, yeah.
So if you're going to begin to deliberate even partially today, I'd say you probably need to close. the record.
That's fine. Okay. So that's logistics of it. Okay. Thank you very much.
yeah, I want to get people their rural ADU development opportunities as fast as possible. But if we're already holding the record open
Well,
for 2 weeks, then I'm happy to wait for deliberations till then.
Yes,
Okay.
it would be really nice to actually have this available to people before the year end, so.
okay. Yeah. So let's do that then. 2 weeks from today is a Wednesday,
It is
August.
the 9th, August 9th. It might be helpful to close the written record on the 8th. That way staff kind of has the opportunity to sort of compile everything and come back when you're at your deliberative session on the 9th, and in order to speak about that, just a recommendation.
I'd support that.
Sounds like a plan.
That's cleaner for staff, but the board's going to have to be comfortable refusing to take any written comments that are presented at the hearing, if that's the case. So if you're comfortable telling folks that show up at the hearing and want to hand you something, I'm not going to take it. Yes, otherwise I would have it be simultaneous with the time of the hearing.
Yeah. Let's do this.
Not to put staff in a bad situation, but if they don't summarize a couple last minute documents, I think we'll be okay.
So yeah, written record open till deliberations, set for the 9th of.
August the
August.
9th at 9 a.m.
Yeah, a regular board meeting on the 9th. Okay, so thank you very much, everybody. As I say, the agenda slipped on us here by taking that kind of methodically, but there was great input and good discussion. Thank you.
Thank you, commissioners.
Thank you, Kyle.
Item number 7, deliberations of possible first reading of an ordinance amending Deschutes County Code relative to camping and other sleeping associated with activity on public property. Let me go right into the next one here. There you go. Yeah, is Eric going to kick this off or?
I don't know that there's a whole lot to kick off. As you
Yeah, okay.
recall, a couple of weeks ago, the board held a public hearing. There was discussions of whether or not to proceed with amending the county camping code. There was a draft put forth by the sheriff's office, also one that the county legal put forth after the board had directed us to put something together. And there was testimony at that time. And this is the date and time you set to deliberate on what the
Right to it.
next steps would be, whether you're going to adopt the changes, and if so, which ones, and to move that process forward.
Okay, so we do have the package today, and it includes a code ordinance package as provided. We have had a hearing on this matter. And yeah, this is deliberations. So I'll kick it off acknowledging that I do support the package that was provided. published as an Exhibit A. So this is slightly edited from what we looked at originally. Property owned or controlled, real property owned or controlled by Deschutes County is kind of the crux of this whole thing. The fact that, the federal land is under federal jurisdiction. There's no joint ownership. It's pretty clear, black and white. And I want to follow that up by saying that, the sheriff is willing to be involved in defining an area. And we need to do that in partnership with our forest leadership. The forest supervisor has mentioned in a phone call I had recently that they want to get back to stewardship of environment, the environment, the forest itself. It's a very complicated situation with people out there. 2-week camping ban is a law that we need to implement, and federal government, I would support federal government asking for help from our sheriff. Sheriff is another discussion with the sheriff. He said he's officially asked, let's define an area. Let's do whatever we need to do legally to, create an area that can be managed by multiple public safety agencies. And we know that this is part of the big picture of homeless issues. Pushing from one area is going to be popping up in another. So just starting to put direction to it from the notes I have.
Go ahead.
Oh, no, you can go ahead. I'll be last.
I would be supportive of the code language developed by county legal. And I would not be supportive of the original proposal offered by the sheriff. But the problem with that is exactly what I believe it was John Apolish brought up at the last during the hearing, which is if we move forward with camping rules on county owned or controlled property, it will actually make things worse out at China Road, because we will, that enables us to clear people out of, East 17th Street in Redmond. It allows us to clear people out of the Juniper Ridge area. And where are they going to go? They're going to go to the place that's not city property, because there's camping rules for that now. And they're going to they're going to go to the place that's not county property, because there'll be rules for that. And where is that? That's out on the federal land. So if we enact this, the proposed code language from county legal without addressing the federal lands, then we're actually just making the problem on the federal lands worse. And I think that's actually, honestly, that's what's been happening for the last few years is we've made it harder and harder for people to camp on local government public property. So there's more and more people going to the federal lands. So so I'm not quite sure how we would want to proceed with these two proposals, given that is the potential dynamic that'll be created. We very much need to do something about unauthorized, over 14-day camping on federal lands. I think that one of the biggest problems for our community is that we're not offering the facilities, the places for people to go, and the wraparound services for people to take the pathway out of homelessness at a big enough scale yet. Our homeless service providers in our community, they are helping people move out of homelessness every single day. But at the same time, our numbers are still increasing according to the point in time counts. So that, to me, you put that success, moving people out of homelessness every single day, with our numbers still increasing overall in our community. And I think the story that tells is that we're not doing the stuff that we know how to do at an adequate enough scale to start to bend the curve on this issue yet. So that's these two code proposals aside, I think that's really where we should be putting our focus, is in providing adequate facilities and services so that people have stepping stones out of homelessness. And then when we've done that, and we've given a lot of people the opportunity to take that pathway out, then if there are people still unauthorized camping in places that we really don't want them to be, then a law enforcement approach makes sense for the people who don't want to take the opportunities presented to them.
Thank you.
Oh, yes. Well, I've been working on China Hat for 5 years now, and last night at 8:45, Sandy Baxter sent me pictures of someone using a chainsaw with smoke coming out of it. And I sent the pictures on to Sheriff Nelson because I know he has hired someone to look at Juniper and China Hat. And fortunately, Sandy was able to contact law enforcement from the Forest Service. But I also sent those pictures on to Portland, where the Forest Service is being, the chief Forest Service for Region Number 6, Elizabeth Berger, who's the new person in charge, showing her what the people in China Hat are dealing with on a daily basis, it seems like to me. So what do we do here? I was told by Shane's legal, Carrie, that honestly, we have to look at the document that our county legal came up with. It seems really, not adequate. As Commissioner Chang just mentioned, does that mean more people will go to China Hat? I actually emailed an email from a resident of China Hat that was 2 years old on my computer yesterday and sent it around. And I said, oh my gosh, this is still happening. And in fact, when I contacted Kelly this morning, she goes, Patty, it's 10 times worse. So the good news is I believe that Sheriff Nelson is currently negotiating with the federal government on doing what he can to add his capacity in, because that's the way he actually has to negotiate with the federal government. And this document is what we can do. It seems like the timing is critical. We did send a letter back to the governor on Monday asking for her permission for adding a managed camp outside where we actually have rules and regulations, because I hear from so many of you and we have to have rules and regulations. And but as you recognize, there are those people that won't go to Bethlehem Inn. They won't go to the Navigation Center. They want to go somewhere with their pets and their RVs. And but they've got to go somewhere where there's rules, and we know we're keeping our county safe. So it's, as you all know, it's incredibly complicated. I feel that this document is the best that we can do today. And we will, every day is a new challenge. And I'm hoping that we will be able to hear from the governor this week and know that we can go ahead with another plan in order to make some more alternatives for those people that choose not to follow the rules currently, and they'll have to move somewhere where there actually will be rules, and to help them regain and enable them and empower them, so to get back in a more positive way of existing in our world.
So with that, a couple more thoughts. This package does, narrow the path. As I say, it really boils down to owner-controlled real property to be able to implement this code. This code is going to be implemented for Deschutes County property currently. And then the ask is for federal government to, get serious about 2-week stays. I would ask our Senator Ron Wyden to take a leadership on this from the federal government. He's very involved with, many layers, very experienced, and it's time the federal government was our partner front and center on this. We need to take action. We're being threatened by wildfire, illegal activity, aggressive behavior, and it's not a good situation. So as I say, it sounds like we may be getting there with this ordinance as proposed. with the content of owned and controlled real property. Sheriff is willing. Sheriff, we have a great public safety staff. We have, a funded public safety system here in Deschutes County, and great people serving. And the pressure needs to be ratcheted up. Compassion and accountability. So when I say, I'm not trying to trigger people because, man, it's an amazing situation. When we talk about this subject, people just get triggered in all kinds of directions. Let's make it safe for everybody involved. The people spending a long time out at China Hat or in other public places, plus our community members and private property owners. So there's a lot of motivation and passion in moving this forward. And I think, it's interesting. We all, kind of say it a little differently, but there's a lot of common ground here also.
Yeah, clearing people from places where they're not authorized to be without options for places where they can be and pathways out of homelessness is just shuffling the problem from one unauthorized location to another.
Something needs to give. We all know that.
Yeah. So I think, on some level, I think that these camping codes are putting the cart before the horse. Until we do the two things in a coordinated and comprehensive solution way, that these camping codes or camping ordinances are pointless. They are not effective in helping us reduce homelessness in our community. Just move this problem around.
How soon will could this code be effective though? 90 days?
Yeah, for 90 days from the second reading. Second reading would be 2 weeks from the first reading. So you could presumably do first reading today. Second reading would be 2 weeks later, and then 90 days after that, it would take over. Keep in mind at the public hearing, we did point out that the prerequisite to all of this is that we have some alternate sites where people can be directed to. So unless and until you have that this code doesn't really mean a whole heck of a lot. So that those sites are going to have to be identified and somewhat developed to whatever level of development you choose to develop those to. And then, just to kind of clarify for folks' benefit on the federal jurisdiction question, the code that the sheriff initially brought forth kind of assumed that the county could assert jurisdiction over those lands. It can't. The federal government is not subordinate to local county governments and city governments and whatnot. They have a supremacy clause and other things that are written into the Constitution that we don't get to tell them the way the rules are going to be. They can agree with us, and we have precedent for that. Elk Lake is a great example where they agree to be policed by our county noise ordinance, and they allow our sheriff's office to go up there and police and enforce the noise ordinance. So there's a path forward, and the code is as drafted by the legal department provides in using that term, and it wasn't by accident that we included the word controlled, county controlled land in there, is that the federal government has the ability to give us limited control of certain portions of their land for purposes of either our code or their own regulations and enforcing those. And again, I use Elk Lake as a great example where that's actually occurring. So there is a path forward to that, but that path forward has to go through a consensual agreement between the federal government and the county, and with the sheriff being the face of that as the enforcement piece that would be, upfront dealing with that. So there is a potential path forward there. I can't speak for the federal government. I don't know if they're going to be amenable. I don't know if it's going to take you, 5 years of red tape and bureaucracy, or if it's something they can do in 5 weeks. I don't know. I don't deal with the federal government. So I did mention last time there's other issues. If the federal government does come on board and we have some sort of process, I don't know how the enforcement of that would occur. Certainly the civil enforcement could be locally through our resources. If it elevates to a criminal process, I don't know if that requires going to federal court in Eugene. I don't know if the United States Attorney's Office has to get involved. Those are questions that we'd have to figure out. I did share this information with our local district attorney. I haven't heard back. I believe he was out of town though for quite a while, so I'm not sure he's had a whole lot of time to put eyes on it, but we have shared this with the district attorney, and I'm sure to the extent that there would be an enforcement mechanism through his office, I can't imagine he wouldn't be amenable to that. Just in some offline discussions I've had with him on the subject, I think he'd be very much on board with assisting any way that he could. But it isn't an all or nothing is what I'm trying to say on the federal piece. It's I think there was an impression that if you accepted the sheriff's version, that there'd be an ability to address China Hat and the federal lands. And if you go with the version that the legal department drafted on the board's direction, that you couldn't. And I would say that's not an accurate understanding. Either one would arguably get you there. I think, unfortunately, the original one where we're just grabbing that jurisdiction, it wouldn't work because we don't have that ability to tell the feds you're going to play by our rules. They have the ability to say, we're willing to play by your rules and we'll sign this agreement. That's how it works, whether we like it or not. That's the process, and I can't change that. So
And then we would classify those areas as county controlled.
those would be deemed county controlled property if the federal government chose to allow us to, for limited purposes of either our camping code or their regulations dealing with how long you can be on the property, what type of uses you could make. They have their own whole litany of regulations too. So it would be in that negotiation between the federal government and, again, I would assume the sheriff is the lead for the county to determine what it is that would be enforced, what they'd be giving us the authority to enforce on their lands. And again, I know it's not nearly as significant, but by example, Elk Lake, we do have precedent for it. We otherwise wouldn't have the ability to go to Elk Lake and enforce our county noise ordinance, but they've agreed to give us that authority. So we're able to go to Elk Lake and enforce our noise ordinance. So that exact scenario could and would work out on China Hat with regard to camping by folks that aren't supposed to be camping and other activities and uses that are occurring that aren't supposed to be occurring. But again, it starts with the federal government being amenable to providing that level of jurisdiction and authority to the county. They have to make a choice to do that, and we memorialize that with a written agreement, like we have in the case of Elk Lake.
Well, Congressman Cliff Benz, as Chief of Staff, lives in Deschutes County. He's been at a lot of the meetings that I've had with the Forest Service, and he is incredibly aware of what we're doing because I sent him those pictures last night. So Nick Schrader, who has taken over as Chief of Staff for the last couple of years, he knows we have to do something, and he is always usually copied on everything that we're dealing with. And hopefully I would hope the feds would step in sooner rather than later, because the number of fires and the bullets and everything that's going on down there, somebody's got to step up.
I'm sure there's a level of awareness. I think what it really comes down to is the process. And I don't know what hoops have to be jumped through at the federal level to get somebody with authority to be able to sign a piece of paper saying Deschutes County, have at it, enforce your anti-camping code on our lands. Because it sounds like from the sheriff, he and his office are more than ready to jump into that task. So
they're working on it.
Yeah.
So this is a code package, as I say, it's attachment A as the proposed package for today. Is there a motion to support this package as written?
Can I ask one more?
Oh, sure. Yeah.
So Dave, you were, as you just described it, county legal's code proposal here. It would be a prerequisite to enforcement of this that the county had provided other places for people to go before we could enforce this.
Absolutely. Otherwise, we're clearly in violation of the Martin and the Grants Pass cases.
And so where does it say that?
It doesn't. That happens separate and apart from this. That then, in theory and hope, within the 90 days in which it would take for this ordinance to become effective, the county would identify those sites so that folks at the time enforcement began could be directed that you are not allowed to be here, wherever here might be, but here are alternatives for you to go to. And in doing that, we feel we'd be in compliance with the Martin and the Grants Pass court decisions.
So it doesn't say it in the code. Well, for people who believe, as I do, that clearing people from an area without alternative places for people to go is pointless. How does essentially how does Martin versus Boise, if it doesn't say it in the code, how do we know that that prerequisite that comes from case precedent will happen. I mean, what holds us, what compels the county to ensure that there are other places for people to go before we enforce this?
Well, I wouldn't expect that I would hope the county wouldn't move forward in an action that we knew from the get-go could not be supported legally. And unless there are alternate sites identified and available, we can't enforce this code. We would be in clear violation of the Martin and the Grants Pass cases. So, and we shared that at the time of the public hearing, that was sort of the prerequisite to all of this, is that there be sites where you can direct folks to, that they have an option to go there, as opposed to wherever here is that you're telling them they're not allowed to be at. And that's the whole premise of the Grants Pass case and the Martin versus Boise case, which again are applicable here on the Ninth Circuit. They're not applicable throughout the United States, but it is that folks that are otherwise homeless have a right to take shelter, and they can do it on public places, if there aren't other available opportunities for them. And the Martin case got into, beds available and shelters and that's certainly, I guess, probably the best case scenario. I think we talked about that in the public hearing as well, that there would be a fully managed camp that's available within the jurisdiction that has however many beds available as you have homeless folks in the community. So if there's 2,000 homeless folks, you need 2,000 cots that could be available on any given night at that facility, recognizing that that's probably a long ways off for any number of reasons, logistics, money, politics, whatever else. That is why we came up with this concept of alternate shelter sites that would be outdoor sites that would have the very basics of some levels of sanitation and water and trash service, and that those would certainly be an improvement on what folks are doing now without any of those things. And I use Dirt World as a great example. What we're envisioning would be some level of services that would be certainly in advance, certainly more humane than the conditions out at Dirt World and other places of that nature. So, and again, it's somewhat of a crapshoot as well. We don't know for sure that the Ninth Circuit Court's going to say that's enough if we get challenged. There's some of this is relying on literally some footnotes in the Grants Pass decision that the court made footnote of that suggests what they might do on the next issue that comes before them. Well, we don't know. This is really all new ground. And if it was easy, I don't think we'd have the Seattles and San Franciscos and Los Angeles and Portland issues that we have. It isn't easy, and people are trying to navigate how to get there and what to do. And I've heard folks say, well, but this only affects the county. Well, that's all we have jurisdiction for initially. We can't tell the cities what to do at this point. We can't tell the federal government what to do at this point. So it's all we can do, but at least if we have alternate sites within our jurisdiction for folks that we're displacing or removing from other locations in our jurisdiction, then hopefully we're addressing some of the concerns you've articulated. And again, I don't know that we're addressing those concerns from anything other than the legal basis, and that is the fact that the Grants Pass and the Martin versus Boise case make it absolutely clear if we don't have an alternate site for folks to go to, this isn't going to get off the ground.
So I'll just offer that if the board does adopt the code, first reading today, second reading in a couple of weeks, county administration, along with our property manager and partner organizations, will begin to identify those alternate sites for board consideration so that the ordinance can be enforced as intended.
I mean, I've been working on managed camp proposals for over 2 years, and we have not, but besides projects where a community service partner lead is taking charge and doing all the hard and creative work, and we can just kind of come in at the end and offer some land or offer a little bit of money. We have not played a very active role in making planned, authorized, structured, regulated outdoor shelter opportunities available. And I believe what I'm hearing is that if we pass this, if we approve this code language today, we are making a verbal commitment to doing that. I guess I would just like to, you know, I don't find verbal commitments
Well, so we have made commitments.
very satisfactory.
And we're living in a box on the state land use system. DLCD, legislature, the governor, everybody has heard about this. Nobody's responded to us. We're letting the federal government know that we're just on the verge of responding to this. No matter which way we go, we're going to be working outside the bounds of the laws of the state of Oregon or the United States of America. So, yeah, I mean, having passion on this subject is one thing, but which law are we going to break? That's where we're at right now. Which law are we going to break?
But the governor asked us, why we couldn't proceed with the partnership with the city of Bend on the South Murphy Road, proposed managed campsite. And, we're not breaking any law. We wouldn't be breaking any laws there.
Commissioner Chang, that acre was so minimal. We actually had 44 empty beds at the Bethlehem Inn in Redmond at that moment in time, 44 empty beds. If we had medically fragile people that actually needed clean rooms and 3 meals a day, they could have gone there. So the issue is much more complicated than that. South Bend has had China Hat and all the impacts for years and years. And as people are telling me, it's 10 times worse now. So please quit saying that. We allocated $399,000 for Oasis Village and the 12 acres off of Highway 126 quite a while ago. That looks like that is going forward, but we've done a lot of really significant help in this county. The $900,000 for the Bethlehem Inn, $200,000 for the safe parking in Redmond. We gave $1.5 million for the city of Bend. I mean, the numbers go on and on, but in Deschutes County, we have a large group of people, homeless people, that refuse to leave their dogs, their RVs, their property and go to, let's say, the navigation center. So what is it? We have to do something outside, and hopefully the governor is going to allow us to give us some executive orders in order to do something for those people so that we can protect the citizens of Deschutes County that have been dealing with issues that just seem to magnify almost every day.
So yeah, this is a code package and you're asking us to do something more right now. I mean, you're saying your verbal of commitment isn't enough. I don't know what that would mean. And as I say, it looks like we have support for this. That's why we can go debate if we want back and forth for a while, but we could possibly move first reading on this too.
That would be lovely, wouldn't it? So should I make the motion?
Please do.
I would just like everyone to note that I think in voting on this code package, we are making a verbal commitment to the community to do more on outdoor shelter opportunities and managed camps than we have been.
In our jurisdiction, outside of a city, I would clarify.
Well, that was our property off of Highway 1.
Or on the property owned by the county.
Yes, that really was. And it's taken longer than we could have imagined, but it's going to happen. I would like to move approval of first reading of ordinance number 2023-013, amending Deschutes County Code Title 11.04 relative to camping and other sleeping associated activity on public property.
Second.
It's been moved and seconded. Any other discussion? This is the topic of the day. We're moving something forward here. This package does ratchet up the whole scenario for public use of land of the Deschutes County's owned or controlled real property. With that, calling for the vote, Commissioner Dare.
Yes.
Commissioner Chang.
Yes.
And Chair votes yes. Thank you. Second reading will be in 2 weeks, that same Wednesday, the 9th, and then we'll go from there. Okay. Item number 8, amendment to the intergovernmental agreement with Oregon Department of Transportation for US 97 Lower Bridge Street Project. This may be Cody online possibly, or Chris. Maybe
morning.
Chris online. Yep, there we go. Okay.
All right, good morning. Chris Doty, Road Department. Before you is document 2023-724. This is an amendment number 1 to the intergovernmental agreement with ODOT for the US 97 Lower Bridgeway Northwest 10th Street project. This amendment will do 2 things. It will modify timing of the county's remaining payment for the project to coincide with completion of the preliminary engineering phase, which is forthcoming here within the next month. It will also include additional contribution from the county in the amount of $1.493 million towards the project, which includes $1.3 million for the pressure sewer, of which $1 million of that is funded via the coronavirus relief funds via then Rep Bonham's allocation. Also, an additional $193,000 for paving work on the Old Bend Redmond Highway in association with ODOT's US 20 project. And this is additional paving we requested to kind of help facilitate a smoother start to our forthcoming Old Bend Redmond overlay project. And plugging that in this IGA is just the cleanest mechanism, most efficient to reimburse ODOT for that work. The total remaining payment to ODOT that the county has will be $9.293 million, of which approximately $5.5 million is county funding and approximately $3.7 million is funded via several grants. So with that, board, I'd be happy to take any questions.
So Chris, what did you say was additional funding or additional we're going to be paying for that? Yes, exactly. What is that?
You bet. So with all the IGAs we've had so far, we've never included the sewer grant to fund the additional $1 million that we've actually had in our account via Rep Bonham's allocation of coronavirus relief funds. So this amendment will push that $1 million in. The estimate right now is 1.3 for all the piping that's underneath new pavement in association with the project. So there's a little bit extra that we'll be paying for that work, which isn't a part of the ODOT project. It's just a part of what they've agreed to include in the project on our behalf. And additionally, there's $193,000 that's coming from another project that we're paying ODOT, reimbursing ODOT for.
Well, it's been a long time coming and the project's moving forward, but it's exciting to be able to plug in the sewer district work associated with the new pavement also. So
yeah, I love that. There's nothing worse than cutting fresh asphalt. And so the fact that the stars aligned here to give us funding to get the majority of that in and under pavement. It also helps facilitate, of course, work that the sanitary district's pursuing. It'll be there for them when they're ready. And so, yes, this is a good thing.
I do want to acknowledge, you called him Rep Bonham, and he is actually no longer my representative, but he's now Senator Bonham, and he no longer does cover Deschutes County, but clearly he's left his mark helping Terrebonne. So appreciate that acknowledgement of his funding.
Bet.
I'll move approval of board signature of document number 2023-724, amendment number 1 to the intergovernmental agreement with the Oregon Department of Transportation for the US 97 Lower Bridgeway Northwest 10th Street project.
And I'll second it.
any other discussion? Seeing none, Commissioner Chang,
Yes.
Commissioner Dare.
Yes, the fact that we have money for the other project in this, we don't have to have that a separate.
We don't. This simply, it acknowledges, we're paying ODOT back for work associated with another project. So this was their idea. And like I said, it's the most efficient way to accomplish the transfer.
And for the minutes, chair votes yes.
Great to see this project moving forward, Chris. Thank you.
You bet.
And when is Highway 20 going to be done? I mean, like every day.
I'm glad you asked that.
We're making progress. It's looking way better, but
yeah, we're past due for an invitation to ODOT to come kind of give the board and community an update on projects affecting Deschutes County. And so we'll extend an invitation to ODOT hopefully here soon to attend a workshop and give us an update on their schedules There's certainly a lot of work occurring all over this county.
Yes.
There you go.
Thank you, Chris.
You bet.
Thank you. Item number 10, COIC grant application request for broadband action team funding. Welcome.
Good morning.
Morning.
This is our new IT director, Tanya Mahood.
Yes.
Is this the first time you sat in
Yeah.
this scenario yet? You were up here during the budget, though, on the other side.
Exactly. Well, thanks. For the record, Tanya Mahood, IT Director and CTO for Deschutes County. Here to discuss the Central Oregon Intergovernmental Council grant application request for state funding for the continuation of the broadband access team, the BAT team, and partnering with other counties for a regional approach to the application. So here to speak on this is Scott Aycock here from COIC, as well online. We have Shelby Knight from COIC and Seth Thompson from the Oregon Broadband Office.
Good morning, Scott Aycock, Community Economic Development Director at COIC, your Council of Governments and Economic Development District. And yeah, as Tanya noted, Shelby, our resilience planner, and Seth with the Oregon Broadband Office will be jumping in on some of these slides on the screen, but I'm going to get us kicked off. Basically, what we're doing today is providing you with a brief update on some of the work that we've been doing on behalf of the county in regards to broadband infrastructure development, big opportunities for making improvements using federal investments to leverage private investment, and requesting some guidance from you on some next steps. So go ahead, Shelby, and advance the slide. Oh, boy, I can barely see that. As noted, we have unprecedented levels coming in of federal dollars, some direct from the feds, some passing through the state to improve broadband access and infrastructure across the nation. A lot of that's going to probably be directed to more rural areas, which is why the counties are in a significant position here in terms of this work. But it's also not just around improving infrastructure, it's also helping folks gain access. There are some subsidy programs that are probably underutilized that folks could utilize to improve their ability to pay for the service, even if it is available. So just wanted to mention that. Going back, I'm going to say it was 2 years ago now or so, the county awarded COIC $300,000 in ARPA funds to oversee the development of a broadband needs assessment for the county, as well as an action plan that would come along with those, sort of how we address those needs. And really, it's a high-level countywide assessment, shows what are the needs, shows on a map what kinds of areas really are probably have the most potential for doing some work, what those priorities are, and what kinds of partnerships we could pull together to improve service. So what we did is, of course, this is not something we know how to do in-house at COIC. We put out an RFP, secured a consultant. Magellan Broadband is the name of the firm, although I think they now have a different name, Shelby, or haven't they changed over?
Yeah, they're still Magellan, but they're under a new company called Entrust. Okay.
So they've been doing the work. That work all along was overseen by a broadband action team, BAT. Many counties in the state have these things pulled together. They're basically public-private resident partner agencies such as OSU and chambers of commerce, et cetera, to oversee all the work and guide it and kind of help direct it and root it in our local landscape and environment. We are almost done with that report. We're actually in the midst of the reviews of their draft final report. So what we would like to do is come back and present the final findings when they're ready. But we have an opportunity we wanted to bring to your attention now. Go ahead, Shelby. Next slide, Thanks. So there you can see some of the members of the broadband action team. It's a broad mix of ISPs, actually county folks are involved, institutes of higher education. Do I see I don't know if the school district is officially on there, but we've done a lot of work with Ben Lapine School District on this. et cetera. So folks around the county that are highly engaged, either have knowledge of broadband infrastructure or understand the needs. So they've been meeting monthly since this started. Go ahead, next slide. Okay, this is where I hand it over to Shelby, our resilience planner.
Yeah, thanks, Scott. Good morning, commissioners. So just briefly want to touch on some high-level priorities that are coming out of this needs assessment process. And again, just an acknowledgement of what Scott just said, it's still kind of in draft form. We're in the middle of our review process, and we hope to bring it back to this body once it's complete for some more in-depth discussion here. But just broadly, we're kind of seeing two buckets of priority work come out of this assessment. So first, are areas that have insufficient service, basically meaning those areas that do not have access to service levels and or affordable access to services that meet their current standards for upload and download speeds. So these areas also tend to have lower household incomes, so it makes them a real strong priority area for public investment as well. So those being listed here, Terrebonne, just north of Sisters, and south of Lapine. So the report goes into more detail about kind of how and why these areas were identified. As Scott noted, there's a mapping process that included some speed map, speed data overlaid with some social vulnerability data. And then we had some pretty in-depth stakeholder sessions and input informing these priorities as well. And then,
I'm just going to jump in to note that those are example areas, not necessarily all the areas. So that would be identified as priorities. So just so you know, those are examples of some rural areas that could be served well and be competitive with federal grants to do actual fiber to the premise versus the wireless solutions for other places. Mm-hmm. Sorry, Shelby, go ahead.
Nope, that's great. Thanks, Scott. And then the other piece to this is, very remote rural locations. It probably makes more sense for us to explore some wireless broadband solutions. If you've just got one or two folks, it might not make sense to have actual fiber to the premise because that can be pretty expensive. And then the other piece, like the other kind of big bucket that's coming out of this is this redundancy and resilience piece for the county. And so our consultants have identified two really key opportunities for improving our resiliency and redundancy as it relates to broadband infrastructure. So right now, much of our data actually is routed through Portland via what's called the Northwest Access Exchange. And this provides some challenges. So, when you route local traffic through distance exchanges, it creates some vulnerabilities and reduces that performance. In particular, it can be prone to failure from like earthquakes and fire, some natural hazards. And so we have a local internet exchange company called Central Oregon Internet Exchange, and they provide most of this for our area. But not all of our local ISP providers participate in that. So this priority is actually really about trying to get more local providers engaged with that local exchange and kind of making that more robust. And then the other opportunity that provides some greater redundancy is investing in middle mile fiber from Bend to Salem. So this is an opportunity to first connect directly to the capital. And it also supports additional, access points for folks to connect along that network route to get fiber to the home or to the business. And then it's also been prioritized because there are a number of stakeholders that have some direct interest in this route. So I think it's mentioned in the report, we've got ODOT, University of Oregon, and some of the communities along that stretch. There are some ISPs that are interested in potentially providing services here, et cetera. So there's definitely some momentum there as well. And then just a note that, while this is still in draft form, it is on our broadband webpage for CYC if folks are interested in just kind of skimming that. Okay, so that was a little bit about those priorities that have come out of this process. We'll get back with our consultants in mid-August again to present that in more detail. So now that we're close to wrapping up that needs assessment, our next steps are really to start beginning moving some of this project work forward. So a lot of the funding is already hitting the streets or will be soon. So we're really, trying to encourage folks to mobilize to take advantage of that. And that includes some pre-work, some prep work, before we can just dive into some specific grant writing and procuring services and building out infrastructure. So engaging the right partners, shaping up some more details of some of these projects, specifically doing like some high level design and engineering work, which is often a significant and required part of these larger grant applications. And then, providing some capacity for grant writing services and actually accomplishing some grant writing. So again, some of the in particular federal grants through like NTIA can be sometimes really technical, heavy lifts. And of course, it wouldn't be all on, one individual organization. Typically, we're looking at public-private partnerships with ISPs too, who can provide some of that capacity. But yeah, essentially looking to just kind of build that capacity to apply for and manage those grants. So thankfully, the State Broadband Office recognizes the need to kind of bridge this gap between planning and actually implementing broadband infrastructure projects. And they're working to develop a program called, what's now called BTAP, the Broadband Technical Assistance Program. And so we have Seth Thompson here from the Broadband Office, who will kind of speak a little bit more to that program here in a sec. But essentially, it would support, the counties at the county level, counties in kind of accomplishing some of these key next steps. So finally, just before I pass it off to Seth, we've had some, initial discussions with partners in all 3 counties in Central Oregon to see if there's interest in applying for this potentially jointly, both because we've heard from the state that they'd most likely prioritize this type of collaboration, but also obviously, there might be some efficiencies there, both in capacity and actual working on projects that might cross county lines. So I will, with that, go to the next slide and pass it off to Seth to talk a little bit more about BTAP.
All right, thank you so much, Shelby. Can you hear me? Can you hear me okay?
Yes, thank you for joining us.
Thank you so much. Yeah, so my name is Seth Thompson. A pleasure to be here. Thank you so much. So I am a project coordinator with the Oregon Broadband Office. So I just want to kind of explain what that means. My job is to provide the technical assistance customer service to the prospective applicants of our programs. So when the applications actually open for BTAP and our other programs, I will be your primary contact at the Broadband Office. I cover basically all of Southern Oregon currently. If you draw a line across Lane County and everything down, that's my region. County governments are especially so eligible applicants for our program. So again, this is a great opportunity for me to talk to you. So thank you so much. So Shelby's expressed some interest in, or through this presentation, I've learned that the Broadband Technical Assistance Program is of particular interest in this situation. That's exactly the purpose of this program. The purpose of this program is to provide, basically pay for the professional services needed to help plan a broadband fiber network. So the goal of this program is to basically, wherever you are in the process, whether you're putting together a needs assessment to sort of figure out who is connected, who is not, if you've put together a partnership, so you know who's going to be doing the actual work for you in your region, so the ISP, that'll help pay for pre-engineering, so all the way up to that kind of final end game and preparing you for the actual deployment programs that we will be offering. So that's kind of this program in a nutshell. If you want to go to the next slide, please. So normally I provide kind of a more robust presentation of our programs, but I can kind of provide a synopsis of where we're at right now. So this slide shows what I've been calling kind of the four pillars of our funding programs: BEAD, Digital Equity, Broadband Deployment Program, and the Broadband Technical Assistance Program. So I won't go into too much detail about what these programs will do individually. Just know that we are in the process of putting together a really robust planning documents to then submit to the federal government to basically show that we can responsibly administer these programs. In particular, the Broadband Equity Access and Deployment Program, there you see BEAD and Digital Equity Program. That's coming from one federal branch of the government called NTIA. What will be these programs, and we're not going to talk about them in this presentation, but those programs won't be accessible to folks until 2025. What will be accessible, which is why I'm talking to you today, is the broadband deployment program, which will fulfill exactly what it says, which is the installation, the deployment of broadband infrastructure to connect folks who currently don't have access to the internet. So those who we would call unserved. The broadband technical assistance program, we are very close to completing what we call a handbook. So we've completed handbooks for both the deployment program and the broadband technical assistance program. And the goal of these handbooks is basically to function as a guide for both our applicants and the broadband office to basically know exactly how to apply for our programs and answer a lot of the initial questions. So that being said, we've completed draft handbooks for both of these bottom two programs there. And they're not final yet, but the great news about the broadband technical assistance program is that we completed our first draft, then asked for a lot of feedback from folks, and we received a ton of feedback to basically make recommendations to make the program more flexible and accessible to folks who really need service. So one of the things in my meetings with both Eastern and Southern Oregon, the number one need from folks is capacity. I don't have the ability to fill out the applications themselves. Who's going to manage reporting? And so the broadband technical assistance program, one of the new additions to it that got people most excited is it will help fund some of those capacity issues. So possibly a staff person, which we would commonly call a broadband coordinator. Several counties already have gone that route. Or someone possibly just to help pay for the actual application process itself. And so all of our programs, we encourage basically teams, we encourage collaboration across counties, just like you're doing in this situation, which is great. So eligible applicants include nonprofit organizations, county and local governments, other nonprofits, basically whoever you need to get to where you want to be as far as connecting folks in your community. That's the goal of what we're trying to do, and that's why we have kind of the door open as much as possible to other eligible, what we call eligible applicants for our program. So in a nutshell, that's kind of where we're going, and I'm really excited to see COIC is headed in this direction. Thank you. I'm available to ask or answer any questions you may have.
Yeah, I'll step back in. So the questions we're bringing to you today are, for one, do you want to keep going on the path we've been on, where COIC has been handling at least a big portion of this work on your behalf, and go ahead and apply when it's available? We thought months ago when we were scheduling this that it would have been announced by now, but it has not yet been officially opened, this grant program. And Seth, did you give, I don't recall hearing if you said a prognosis for when that would happen. I know it's hard to do.
Yeah, so yes, you are correct. So just to give a quick backstory, we envisioned providing and opening the broadband technical assistance program months ago. But again, early feedback was we need more what we call eligible activities. We need the program to be more flexible. So we took the whole program back to the drawing board, submitted a request to receive information back, got a ton of comments, and basically took the program back to the drawing board or the process of making it more flexible. I reviewed one of our final drafts just recently, a few weeks ago. So in the coming weeks, the final handbook is expected to be accessible folks to flip through and reference and guide when the application actually opens. So when the application itself, the application window actually opens, this program is available for application. That is to be determined, but we want to give folks plenty of time to look at that handbook and identify for themselves and their community how they want to apply. And that's kind of where we're at right now. So first order of business is look for the handbook, and to answer your question, it's not at least half of your question, the handbook will be accessible to folks to review in the coming weeks.
So we don't exactly know when the program so the first question is essentially, do you want us to go ahead and apply on behalf of the county when it does open for those next steps that were outlined in the presentation? And the second question is, if so, or even if not, do you want to consider taking a regional approach and working with your peer counties in Crook and Jefferson counties and with one regional application, assuming that that will be allowed. We've heard that it would be, but I guess until we see the final, then we don't 100% know that. Is that right, Seth? We don't know that yet?
Correct. Yes, please focus on the guidance provided in the handbook when it is released.
Alrighty. So maybe what we're really asking for is consent to continue on this path for now. I think probably what makes sense given uncertainty about when the program will be opened is what we might want to come back a second time when that does happen. It's up to you how you guys want to proceed with this. But anyway, these are the broad questions. And one of the reasons to look at working together regionally is, yes, there's the opportunity for some economy of scale, rather than all three counties kind of doing their own thing and trying to build grant applications as well as activities to deliver on it, kind of investing in a shared services model there. But the other is that some of those needs that we've identified, particularly around resilience, redundancy, those are region-wide. That is not just specific to Deschutes County. There could also be some other actual infrastructure development projects that would cross county lines and potentially make sense to work on together. So that's what we have for you. And I don't recall if there's another slide, Shelby. Nope. Okay. So that's just pause for questions or comments or anything.
Okay, so my question is, there is this massive pulse of federal state money available right now for broadband investments. You're talking about getting funds to do preliminary design and engineering for some priority projects. How do those things line up? I mean, I assume you need to have your preliminary design and engineering all done in order to apply for the capital dollars. But how long are those capital dollars going to be available?
I'll start with an answer and then kick it to Seth. So first, I'll note that the preliminary design engineering process actually does not take that long. So that's the good news. We just did this actually with a consulting firm and the Black Butte School District for the Camp Sherman area. And I don't remember the turnaround, but it was in the weeks, not in the months in terms of getting that work done to be able to be shaped up for a grant application. So that's the good news part. In terms of how long the funds will be available and from perspective of timing and make sure we don't miss the opportunity. Seth, can you speak to that?
Sure. Like everything else that I've obviously talked about today, we have to be purposely vague simply to not spread misinformation. So I will say this to clarify, Commissioner, one statement you made. We actually don't have the funds yet. The fundings will not be allocated to us for quite some time, well into 2025 for specifically broadband equity access and deployment program, which is, I believe, what we're referring to. That's the primary chunk of federal dollars that's been in the news, upwards of $700 million, and that'll be just for that program. Per our forecast, the dollars, so the money from that program, for deployment of broadband infrastructure, connecting folks, will be accessible from 2025 to 2029. So a really common question we've gotten from folks is, am I going to miss the boat? Am I going to miss the funding opportunities? And the answer is no. None of our programs are actually open for application yet. We're still very much in the planning phase. So having this opportunity right now to talk is absolutely key to that process, having the conversations and actually setting the table for when the deployment will actually occur. That's the next current step. But just know that basically based on current projections, you'll have basically half a decade to access those funds.
Another response, just for context, is that I think the preliminary design engineering, obviously that's extraordinarily important, but another piece that's important is the getting partners together to work together, because no one entity usually, like, yes, an ISP is usually in the lead, but the community, other partners, the users, kind of the deal making and building the projects is another piece of what we can use the BTAP funds for. So there's the technical side, and then there's the deal making, brokering almost, of pulling the right people together to make it a successful project. That's another piece of the puzzle.
well, that sequencing sounds good to me. Yeah, if we're trying to just decide what motions we're going to make today, I would be supportive of COC applying for these funds and and representing the county in that process. And then also I would be supportive of us doing that as part of a regional approach with the other two counties.
Are those supposed to be separate motions?
Oh, I'm not making motions. I'm
You're
just kind of, if we're trying to decide whether we want to do one or both of these things or not, I'm just signaling what I'd support.
So I kind of struggle with the big picture here. A lot of federal dollars coming down for broadband internet. A reference point for me is when you can stream full screen video, a Netflix stream, you kind of have what you want. And I remember seeing this when you had a computer, when a 286 or a 386 can play a DVD, all of a sudden you're like, oh, it's done. We don't need much more. But then an internet connection, once you can have, mom and dad watching a movie and the kids streaming another movie, all of a sudden you got two. So I understand, the bandwidth. Also, Crestview Cable was, internet provider, TV provider that became an internet provider, bought out by Ben Broadband, and now TDS out of Chicago owns it. So, as I say, when you learn about the big picture, we also have the history of rural telephone service in the United States of America and mail service, all these big services that were out there. We're going to see a design study or whatever, this report coming out, which is, I think of it as a heat map. This is a person that can get, 25 down and 10 up or whatever the numbers are right now, or this can only get 10 too. Okay, now we know where people can get this and people can get that. How much money are we going to study? So maybe Seth, you can put this in perspective for me. And also I see a big difference between urban areas. There's neighborhoods, once you run a fiber between a couple blocks, all of a sudden the whole neighborhood could light up. But we're talking about rural here. We need to run many miles to get rural properties online for these speeds. So with that said, as I say, I'm just kind of lost. This is the world I think about when my experience that I just explained, but yeah, what's going on here? What's the big picture? Do you have any thoughts, Seth?
Sure. I mean, I can kind of provide a perspective of our end goal. So the objective of the Oregon Broadband Office is to connect as many folks to high-speed internet access who currently don't have access. Our number one priority per federal guidance is to connect those who are unserved, so basically have very slow internet or none at all. And the next priority is underserved. And so a lot of questions we've been getting from folks is all the money going to go into urban settings? Not true. They will still have access to the funds, but the priority of all of our programs is going to be to connect folks specifically in rural settings that currently don't have access. So what that means is we're basing all of this on guidance from the Infrastructure Investment and Jobs Act. So there's a huge influx of money coming from the federal government to support these projects. And the end goal, maybe this is kind of a good way to put it, is folks who live in settings that classically have been disconnected from the internet don't have the same opportunities as those living in urban settings. And so the goal of what we're trying to do is completely residential focused. So we're trying to connect people's individual houses to high-speed internet. So that's what we've been hearing from folks, specifically in Eastern Oregon, is there's this kind of epidemic going on of young people leaving home, pursuing their fortunes and their future somewhere else, maybe going to school, maybe going to a trade school, and they don't come back to their community to re-enrich their community. Really, that's what we're trying to do, is maybe they can access online internet, resources, take classes from Oregon State University from the comfort of their own home. Yes, streaming Netflix is very important, but also the internet is involved in so many aspects of people's lives that they they kind of take for granted. Personal banking is one. Healthcare, so specifically in Eastern Oregon, telehealth is huge, and so a lot of our programs will be helping folks who have mobility issues, for example. If they can get connected to the internet and stream or access a Zoom call to visit with a doctor, that's huge if they have trouble leaving their house already. So that's kind of is that sort of the big picture question?
Well, so and then I kind of boil it down to private industry opposed to government. So, government's going to spend tons of money doing something. And, if it's getting, as I say, rural mail service across the country, rural telephone service across the country, that's, those are big pushes that were exciting back in the day, and they're very influential. So if this is that, or if it's urban, and I mean, I'll acknowledge, in fact, where are you located right now?
I'm in Springfield, Oregon.
Yeah, see, I mean, we just dial it up, click a link, and we're on a call here, which is amazing. So, but I just kind of struggle with the concept of how much government building out the internet is this, or is this the rural internetification of the United States of America? So, I mean, I'm not too wound up on this. I'm just sharing my thoughts. I kind of scratch my head. What's going on?
Sure. Just to clarify one point, the government won't be actually doing the work. That's the big question, and that's what we've been telling folks. County governments are really the question, specifically for regional governments, is what role do you want to play? Do you want to manage the infrastructure? A lot of people say, no, I'm going to leave that to the private industry. The role of the federal government, if this maybe helps provide some clarification, is simply to provide the funding for the infrastructure and the planning. So the planning first and then the infrastructure second. We won't own the infrastructure. We won't, by participating in our programs, you won't give up anything to the federal government. Is literally, we're just trying to connect folks and by providing the resources for folks for county governments, hopefully to work in partnership with internet service providers in their region to connect folks. And that's really the government's role. We're very separate. Just our role is to provide funds.
So then, as I say, I'm just thinking practically, if once we have a heat map product, which is maybe this report that's coming out, then we're going to say, okay, southern, south of the La Pine or whatever, we already have high-speed internet, terminated fiber, multiple fibers in the city of La Pine, and then you're going 5 to 10 miles south. If you're going into northern Klamath, I don't know where the next termination point is or off-ramp is for the high-speed fibers that are in the ground. Because I remember 25 years ago when they were trenching all the way up and down Highway 58, I used to drive it once in a while. And there was many years where we were standing behind a flag line waiting for that, that moving installation to finish. There were a couple of years, as I say, I think that was about 20 years ago. So I'm just trying to put it in perspective.
If I may, I'd just note that the model that we've been assuming and is that the funding that goes to build stuff would be used to leverage private investment. So it would be going to those private ISPs to shrink the return on investment period or whatever it is so that they can actually go forward with expansion plans that they otherwise wouldn't have been able to afford. The only other model that I've heard discussed, and I don't have an update on where they're at, but I know that at least at one point, the community of Sun River, the homeowners association, they were looking at possibly building out fiber and then leasing that fiber to SP to manage, so they would actually own it. I don't know if they're still even considering that or not. That is the other model. Maupin did that. The only place that I can recall that it's government owned and provided, at least used to be, Sandy. We haven't really had those kind of conversations here. We've had all the ISPs at the table, and the assumption has been that the interest is in supporting their work. So just want to note that.
As I say, I still don't feel like I'm really grounded. I mean, what's a BAT going to do for the next 2 years?
They would be overseeing all of this, turning the corner from analyzing to building projects.
But a broadband action team is a cross section of a lot of different people coming to a meeting. Mm-hmm. They're not going to be the engineers. They're all going to have the same heat map. Said, oh yeah, we should put more internet here, here, and here, more capacity, more backbone. So then, what does a broadband action team do for the next 2-3 years?
Yeah, I mean,
and as I say, I'm just looking for this. I don't know what this is.
I think what we've found so far is the broadband action team has asked some of the right questions, frankly, from our consultants, that they weren't investigating some things that were needs that they didn't understand because they're not from here. They were helping us make connections with partners that we didn't know about. They were helping us determine where, priority, like first, second, and third priority, things like that. How that moves forward, I honestly think they'd be meeting less frequently, more quarterly or something. And we would be building small project teams, not really formal entities, but project teams that are taking on each of the individual projects represented in the heat map.
And as I say, I mean, some engineering or design group, either from an existing corporate ISP or company or an independent group would say, okay, let's get the pencils out and design this thing.
They would do it. I don't remember the name of the firm we just worked with. Shelby may recall the one that did the work for Black Beach School District, but there are a number of them out there that do that pre-engineering work and kind of shape you up. But you're right, ISPs have those teams in-house too. We could be subcontracting, but with either for that kind of work.
Yeah. So as I say, I mean, following this topic, it'd be interesting to see who's making the money decisions where.
And I also want to offer that there's two further things we can do. We're planning on bringing you the final report for a review and discussion, which will have a lot more detail on what this.
Yeah, and I'm looking forward to seeing that.
Yeah. And then also, I think it might make sense if you're interested to learn more, as we get more detail on the funding programs, what they do and do not do, we could have the state come back and speak to a greater level of detail on that. So I'm just not committing you, Seth, but just noting that that's something we could do.
And I also think we might be able to, end up in a situation where, the broadband action team and the federal government's going to fund something someday in the future where a private company would have just put a wire in next year instead of waiting 2 or 3 years. So I'm just saying this is interesting.
One of the fundamental, like when we're talking about rural areas, one of the fundamental dynamics is that the private sector doesn't think it's worth their investment the reason that Maupin had to work with the consortium in Wasco County to bring fiber there is because CenturyLink and others said there are too few people there to justify us spending the money to bring the infrastructure there. So you had public coordination, public investment to get the infrastructure in place. And then there's plenty of ISPs who are willing to service people, but there's just not, in rural parts of Oregon, there's not enough people for the private sector to want to go there. And so if you want to bring a broadband to rural Oregon, you have to have a certain amount of public coordination and engagement and sometimes investment to make things happen.
Well, and I would assert that this is at cross purposes of rural development, accessory dwelling units, wildlife overlays, and limiting development outside of cities. I mean, think about that, and we get to see that as commissioners. We get to see all these topics. This is kind of crossways to some of the things we hear from people about why we can't authorize something.
This actually reminds me of going to my mother's house with my kids and there was no internet. Oh my gosh, you would have thought they were.
Is that good or bad?
Well, they were lost for a few seconds. But when you talk about south of La Pine, you're actually talking about Klamath County. So is this agreement going to be something with Klamath County? And then I have a smaller problem, but the internet capacity at the Veterans Village I'm hoping that something has happened and it's going to be existing in the next little bit because they have been missing their internet capacity and they're right here in the city of Bend. Somehow their agreement got lost in a shuffle. And that's right here in Bend.
I don't know the specifics of that, but I would note that there are places within the city limits all over the region that, particularly neighborhoods in certain areas, that would not meet the standard we're talking about of internet service. So I do anticipate some urban projects coming out of this. On the south of La Pine thing, honestly, I think our consultant was a little. I think what he was referring to there is different areas in South Deschutes County adjacent to La Pine, because you're right, Klamath County was not scoped in this. We've had to correct his geographic knowledge a few different times. He's on the East Coast.
Okay, well, the Health Council actually goes down to Gilchrist, Central Oregon Health Council, even though they're not, Kirker Jefferson. So
yeah,
I was just wondering if we had that
Yeah, we haven't engaged with Klamath County at all in this process because it was just outside of the geographic scope. Doesn't preclude us from doing so going forward.
But if you're saying that working together might be a good idea, maybe we should engage with them because it clearly seems like, aren't we closer to Gilchrist and Cross?
Great point. And not only on this, on other issues too.
Right.
You know, a lot of those folks, they look to Lapine and Deschutes County for services, not Klamath Falls. So that's a great point. And we'll just, we'll reach out to folks there and see what's already underway.
Okay, good.
Thanks.
Thank you, Scott.
Are we ready?
Yep, yeah, as I say,
I move approval of COIC applying for state funds for the broadband action team on the county's behalf. At whatever time the application cycle opens. I don't feel like you need to come back.
I'll second the motion.
been moved and seconded. Any other discussion? Seeing none, Commissioner Chang,
Yes.
Commissioner Adair,
Yes.
and Chair votes yes.
Thank you.
Thank you.
See you
Thank you.
soon.
Want to do the second motion or is that just kind of?
Well, so yeah, it talks about a regional approach
Let's-
for Jefferson and Crook. So could you explain that a little bit? I mean, the broadband action team is a COIC effort, is already tri-county. Is there anything formal about that?
At the current time, the broadband action team is Deschutes County only. Jefferson County has one as well that
Okay.
they've managed, and Crook County does not have one. So we are, and Shelby may have a little more insight on this than I do, but are in conversation with both Crook and Jefferson counties on the same question. And I believe we have a meeting later this week, even Shelby with Crook County.
Yes.
Conversation so far, Jefferson County they've been very interested. So but nothing formal yet. Is that right?
Yeah, that's accurate. I don't have anything to add to that.
And I would add Klamath County, maybe a portion of it, the northern portion, because if we're doing this, it makes more sense.
Good point. Thank you.
Yeah, it would help them out.
Do we need a motion to?
Yeah, that's proposed that we acknowledge that we
regional
want
approach,
to.
or Can we just say, yeah, a regional approach is good?
We don't need it. Up to you.
Yeah, so
I think at this time, just articulating your support,
Willingness.
because it would come back by way of an IGA or something like that anyway.
That's right.
Thumbs up for me.
go ahead and make the motion. Or you're
You need a motion if.
not motion. Okay, moving on.
It would come back with a.
So our Our
I
schedule
think
said we were
Scott
going to
was
be
just
done at
looking for
11
a
today.
General
Yep.
temperature here.
Yeah,
Thank you.
yeah, thank you.
Thank you.
Item number 10, deliberations, destination resort text amendment.
And yeah, a little bit bigger copy of that decision matrix in case that's too small.
Bigger font.
You got an extra one for my old eyes? Thank you.
That's mostly today.
Oh, good. I appreciate
Thank you.
that. That little thing. Killing me. Killing me, Smalls.
So this is deliberations on this matter. Decision matrix provided.
Self in order here.
And this is the same matrix that was published in our agenda packet previously,
little
just
bit
larger
larger.
print, just so everybody understands, nothing new here.
Absolutely. And thank you, commissioners, for the record. My name is Tarek Rawlings. I'm the Senior Transportation Planner for the Community Development Department. Today is the deliberations item for file number 247-22-22-000-835-TA. It's a legislative text amendment applied for by a private applicant, in this case, Central Oregon Land Watch. They're a local nonprofit agency. This is following a planning commission hearing and review, as well as a public hearing before the board on July 12th. This also follows the close of the record that Friday, the 14th at 5 p.m. So we've incorporated sort of anything from that written record, any of the really the technical merits of what we need to potentially work out today for deliberation. And before you today, what we just handed out was a little bit larger format of that decision matrix that's included in your packet materials. That's really outlining the two main issue areas that we've highlighted for the board to deliberate upon. You've heard a lot of public comment. The first, and this is on pages 133 and 134 of your packet. So this would be pretty much just addressing the two main issue areas that were highlighted through the review, the technical review of the process, as well as through public comment. And so if there weren't any, I'm happy to kind of answer any initial questions or coordination you might want to address right now. Otherwise, we could start talking about the decision matrix.
So with this item number 1 on the decision matrix, I guess I'm going right to it.
Sure, yeah, sounds.
Was this discussed at the planning commission?
This was not discussed. So yeah, in the kind
That
of
was my
fourth
question.
column, this is one of the issue areas that was really not addressed at the planning commission phase. So this deals with just to kind of reiterate the issue area for the audience and anyone else just looking today. The question really summed up is the proposed text amendment unlawful under Oregon Revised Statute 197.455, such that the amendment of the county's comprehensive plan designation for destination resort overlay requires a mapping amendment first, essentially, is what that's asking for. There's been an assertion at several points through record that this is the incorrect process, the text amendment, and that a map amendment or plan amendment is what's actually required. Just for kind of our internal pieces, or if you have questions just initially on that issue area, I'd be happy to discuss as well.
So taking a half a step back, then we have a destination resort overlay or designation on some parcels. I think of Dial, and I was able to pull it up yesterday. You can open up a layer that shows existing mapped parcels that qualify, and those property owners asked to be included when that map was created, a big picture item many years ago now. And then that history of that map by state law can't be updated more than every 30 months. But that's a designation, a zoning designation, correct?
Correct, of the map itself, where that zoning is located is a map feature. And you're correct that it can only be updated every 30 months per that revised statute.
So just terminology, parcel can be zoned resource or non-resource, EFU or rural residential MUA 10. But having that destination resort overlay is also another zoning, another designation that it's included with.
Correct. It's another zoning district on top of that base zone, which are what those zones are commonly called. Exactly.
Okay.
Sure. If we want to just maybe go into a little bit more on that issue area. So internally, legal counsel, county legal counsel feels that this text amendment is fine to process as is. There was not really any legal challenges, nothing brought up in terms of a lack of clarity on whether we could proceed with this one. There's some discussion of whether the mechanism in that legal language automatically applies from that state law. And just kind of a bit of anecdote on that one is that there's case law specifically from LUBA 2022-011, which cites Gould Golf, which is essentially saying that there's not an automatic update of that code language, or that essentially a text amendment would be required because that language doesn't trickle down into county code automatically. That's one reason potentially for why this text amendment is the mechanism that's being used.
Well, yeah. Any other thoughts?
Nope.
So yeah, I would come. This is a text amendment kind of around that. So it isn't proposing to change the zoning. It's just
correct. It's proposing to change the language within which that zoning is administered, essentially the text of that zoning code, more or less. And really the overall question, just to kind of reframe it, is, or the issue is that the board has to determine whether this application requires a map or plan amendment to address this Oregon revised statute related to destination resort siting. Just to kind of walk through that last column here, if the board does agree with the applicant's response, and really the applicant asserts that the specific subsection 1, subsection A related to this 24 air mile limitation, their assertion is that only allows for its implementation through a text amendment process, and that doesn't prohibit all destination resorts. If it prohibited all destination resorts, then a mapping amendment would be required to remove that zoning. That's the applicant's assertion, really. And so if the board agrees with that response, they can deliberate to make findings reflecting that, is one option. And that the map and plan amendment is not required, map/plan amendment is not required. And then really just for the full suite of options, if the board disagrees with the applicant, or just otherwise with this text amendment mechanism, they could make a finding that the plan or map amendment is required. And so this is potentially this text amendment is unlawful under that particular Oregon revised statute. If that was the way that the board deliberated, we could kind of look at next steps in terms of what that map amendment might look like. But those are really the main options for the board on this issue area.
So I support making a decision on this matter and then getting to the next kind of the deliberation on the package proper, because then number 2 is depending on which way we go.
Right.
Correct. Yeah.
Well, I think that it's pretty clear that we are not revising the map. Destination resorts will still be allowed in all of the places that they were originally allowed under our earlier map. The nature of those destination resorts, moving forward will be different, but we are not changing the map. People will still be able to build destination resorts in all those places.
One, I would agree, this is a lawful application asking a very specific change to future applications.
And I'll follow the advice of our legal counsel, offering that they will retain their authority for your, the third column.
Right. Very good. So it sounds like we're in agreement that a map and plan amendment is not required, and the process can proceed under this text amendment. So thank you very much for providing clarity on that issue area.
So yeah, basically just at this point, before we get to number 2, let's get clear about the position here. So I do not support this text amendment and I see it as a shortcut, removing opportunity for, future discussions about anybody being able to, have a market-based destination resort like we traditionally have. So I would move, I'm supporting denying it. So just making sure we understand where I'm at.
Well, it's still a market-based destination resort opportunity. It's more of a resort though, and not a rural subdivision. You'll be able to build amenities, guest lodging, and dwellings for the people who work there, which makes it more like,
Disneyland.
Well, it makes it more like, maybe like a big rural hotel with amenities, or a bunch of guest lodging units around amenities, which if the intention is to attract tourists and provide tourism opportunities, that certainly is still available to any of the entities who own those properties. So saying that it's not a market-based opportunity is, I don't think, accurate.
And, any further discussion on issue area 1? And really that's just providing clarity on the mechanism of the file type, more or less. I think just to your point, Commissioner, we could go into issue area 2 is really where we find out if this thing gets approved or not, or really the language of it.
Well, let's see what Commissioner Dare has to say.
Certainly, yeah.
Yeah, let's go to item 2.
No, I'd be happy. Honestly, we're not in any rush. I'd be happy to discuss anything on either issue area.
No, I'm following the guidance of our legal,
Sure.
which I've chatted with them, and they say it will retain their authority to potentially develop a new destination resort provided. So I'm going with what legal has said, that I can support this. The map.
Noted. And any other, if there's any other discussion, happy to entertain that. If not, we can move on to number 2. and looking.
That's fine.
Looking like.
I mean, yeah, as I say, I'm trying to get clear on what we're doing here, because when we see number 2, would we include recommended language? And if I'm proposing that we deny the application
Right.
up front, I don't know that we need to do number 2. So that's where I was speaking to.
Sure, and yeah, just to your point, Commissioner DeBonne, there's in that final comment on issue area number 2, the very last paragraph potentially addresses your thoughts on denying the application. That option basically says that there's no agreement to any kind of modified language, the original proposal by the applicant, and then just rejecting the amendment as proposed, or even the modifications that are proposed. So that might be what you're looking for on that second issue area, at least.
Yeah, because I mean, if there's a second vote for disagreeing with the proposed text amendment, then we're not going to proceed with item number 2.
Correct,
is what I was-
exactly, yep.
It didn't sound like there was 2.
And that's what I'm searching for.
We could go in a little bit more detail in issue area 2 if you want me to just kind of frame that for the purpose of discussing it. But yeah, it sounds like the chair might be entertaining kind of a general discussion on whether the other commissioners would like to overall approve or not approve this proposal. If it helps, I'd be happy to go into a little bit more detail on this issue area, but I'm also here to just collect any kind of thoughts the board has.
Well, the question's going to remain on item number 2, because we have attachment number 2, the appendix.
Correct.
And there are 4 options there, I believe. Yes, 4 options. And if I will only vote for one of those options on that appendix, and Commissioner DeVone is going to vote 0, and Commissioner Chang is going to not vote for it either, then is this a moot position? I mean, are we like?
It would be, yeah, I mean, if there's disagreement over the potential languages or modified languages, that's something that we'd have to kind of hone in on with a little more detail, I would say. So far, I haven't really heard, you're the most detail I've heard on any discussion of modified language. So that would be, it's really the options here, just to lay it all out. We have one option that Commissioner DeBonne has kind of talked about a little bit, which is to deny the proposal itself, like on face value, that this, either the modified version of it, the applicant's original version, or anything else is not something that would be approved under that option. The other option is to essentially approve as the applicant has listed the language in their original application materials. And then really the third option is to pick from one of the modified language proposals. And staff and legal counsel have kind of identified the one of the 4 that would probably be the most ideal in terms of clarity and specificity. Those are really the 3 main options before the board right now on this issue area, and really kind of generally about this text amendment proposal.
Well, I would say about the different proposals that we received. I'm following that, that in staff's opinion or interpretation, these revisions are not necessary. That the intent that, this only applies to new destination resorts were covered there anyway. But if it makes people feel better to put it explicitly into the language here, then I'm comfortable doing that. I mean, I don't have a problem doing that. I would support. I do think that the Caldera Springs Real Estate's proposed text modification would be my preference. But
okay.
I'm also somewhat flexible on that if that's what it takes to get this done.
Yeah, I'll note that initial position. And any other discussion just on any of the proposed modifications or otherwise, or?
So I'm going to support my position a little bit more here, just for information. So lands have been mapped as eligible. State law was followed in defining our zoning maps and our overlays. I took offense at some emails saying that we're contrary to state law. We're not contrary to state law. We're following procedures. People have scoped out the fact that there are some parcels that could be included for future destination resort discussions. And remember, this is a legislative matter. We don't have any destination resorts that anybody's proposing. I see this application as a shortcut to stopping future opportunities that may or may not be on the horizon. I don't know of any that are on the horizon. Obviously, we want to acknowledge that water is a serious issue. When we see people talk about resorts, and the Thornburg specifically recently, it was stated that they want to be a very environmentally friendly opportunity for a rural living. The state land use system has put us on this track of destination resorts, which has been the thing that works in Deschutes County. Future amenities hopefully wouldn't need to be a golf course, and that's just a high level statement, because we all know that green grass in the desert is a very costly endeavor because of the water system. So as I say, I'm just supporting the fact that I want to thank Central Oregon Land Watch for being involved at this level. It was a commitment to writing a $6,600 check to start this process. But as I say, I just don't support it, and I don't think we're outside of the state law with the lands that have been mapped.
If we're getting away from the substance of these issues, then
I think those were the substance of the issue.
well, not exactly. These specific issues on this matrix are pretty detailed, and you're jumping to the high level policy level. I guess to make the other policy argument, destination resorts were an opportunity that the state legislature offered to rural, economically distressed parts of the state back in the 1980s. That descriptor certainly fit Deschutes County at that time. I would say that saying anyone who says that Deschutes County is economically blighted at this point in time, and needs destination resorts to bring more people here, to attract more people here, is not really living in the year 2023. And that the destination resorts that we have and we have approved have provided tremendous service to our community in bringing people and investment here. And the legislative intent from 1984 does not apply here anymore. It is a policy that was created for rural, economically blighted communities, and that is not us anymore. And so the need for destination resorts, the way that they were needed in 1984, is past. So that's my big policy statement about this. And that's why I would support approval of this application.
Stay, and I'll deny it. So that's yeah. That's where we're at.
I'd suggest the board's articulated, I think, 3 motions, and it sounds like maybe you're at a point where you start making the motions and see if you get a second, and then that might ultimately decide where you end up.
So, I mean, I'll officially make a motion to deny the file number 835 TA Destination Resort Combining Zone proposed amendment.
I won't be seconding that, but I want to give adequate time for consideration.
Park, are there any mapped destination resorts outside the 24 air miles of Bend at this moment in time?
No, of the 5, they're all within that 24 air miles of the 5 existing mapped.
Okay,
And Thornburg's included in that 5.
and it's included too. Okay. That's what I thought.
But Thornburg has already received an approval from Deschutes County.
Correct, yes, exactly.
So it's not affected by this this change.
Correct, exactly.
And there are, if I remember correctly, they're beyond the 24 air mile zone. There's still eligible destination resort land in South County.
Correct. Probably 20 to 30, admittedly, like kind of smaller acreage properties, but definitely on the southwest, just outside of that perimeter.
Eligible for the historic style destination resort.
Correct. It depends on a lot of different factors to really jump through all those hoops, but they are mapped and have that zoning and they would not be affected by that 24 air miles. So you're correct. They would still be able to technically pursue that sort of historic definition of a destination resort.
So there was a motion made. Now we're in discussion. Procedurally, is that,
Well, I think it was a question being asked. I mean, right now, we're just waiting.
because I want to respond to that too now.
Yeah, we're waiting to see if there's a second. If not, the motion would die for lack of a second.
Well, so if you looked at destination resort mapping areas that are outside the 24 air miles, there's some 1 and 3 and maybe 5 acre parcels that are not contiguous. So we're talking small parcels. So there's really no, please don't assume that there's somebody somewhere in Deschutes County that's on a map that, might qualify for a destination resort.
Well, I wanted to give time for consideration, but I'll go ahead and try a different motion. I move approval of file number 247-22-000835-TA.
And Commissioner Chang, I might just ask a little clarification on whether that's the original proposed language or any of the modified language in that motion.
With the proposed text modifications from Caldera Springs Real Estate.
Very good. Thank you for the clarification.
Thanks for calling that out.
Okay, for me to second that, I just want to confirm that is from attachment 2, the appendix, and that is item number, the first one, correct?
It is, sorry, getting over there. It's underneath here, excuse me. It is the first one, called Caldera Springs Real Estate by Steve Holtberg.
Okay.
Submitted on July 11th. You got it.
All right. I'll second that motion.
Very good.
Okay, any other discussion? Seeing none, calling for the vote, Commissioner Chang,
Yes.
Commissioner Adair,
Yes.
and Chair votes no.
Thank you very much, Commissioners. I
Okay.
think the plan, if we want to do a little bit of calendaring just quickly, I can come back for a first reading of this ordinance, essentially just reflecting the motions and some of the whereas history. It looks like this would be a Wednesday item. It looks like our nearest Wednesday would be Wednesday, August 9th. And for first reading, it would come back 2 weeks later, Wednesday, August 23rd. If that works for the board, I'd be happy to entertain any other dates you have in mind as well.
Yeah, just whatever's appropriate, and we'll put those in there.
Sounds good.
Sounds fine.
Very good. Thank you so much, Commissioners. I'll see you on the 9th then. Appreciate your time.
Okay. Item number 11, 10-year ground lease discussion. This is with the City of Redmond. We're going to get to the end of the agenda yet today. And thanks for coming, everybody. There was a couple hours of discussions, other topics.
Commissioners, for the record, Christy Bollinger, County Property Management. We also have our partners here from the City of Redmond, so I'll just ask them to go ahead and introduce themselves.
Morning, Chair and Commissioners, Kat Zwicker, City Councilor.
Keith Witowski, City Manager.
And Keith Lights, the attorney.
So we're here today, so just to go back in time a little bit, based on board direction, county staff worked with the city of Redmond to draft a 10-year ground lease, which would provide the city 10 years term on leasing property from the county in East Redmond. And that provides for 12 acres. And the purpose of the lease would then be for them to turn around and sublease to community service providers. And that would include for Oasis Village, for shelter units, and also for potentially a managed car campground, basically. So with that, I'll go ahead and pause and hand it over to the city for further input.
Well, it sounds like all my talking points were done. Essentially, it is the 12 acres we've talked about for the Oasis Village project and for an eventual kind of a managed safe parking camp. We are also asking for your one change to our approved lease, and that is just to remove in section B 1.2, just the transfer of the lease clause. We feel like that's probably a little bit faster than we need to be going. Just says in the event the leasee requests that the leaseor transfer, whether directly or indirectly, voluntary or involuntary by operation or law, all or any part of the site to Mountain View Community Development, leasee agrees to cooperate with an orderly termination of the lease and transfer of the site to Mountain View Community Development. And so we feel like we don't really know who that safe parking and partnership will be in the long run. So we're just going to remove that and wait for that to occur organically among our partners. And I will state we had a really productive board meeting with all parties last night. So things are looking like we're going forward very quickly.
Great. So
Wonderful. We've been talking about this property for a long time. Yes, it's outstanding.
does the version in front of us have that clause? 1.2.
On page 2.
Yeah.
Page 2.
We'll strike specific.
Section B under witness, and
The page 140 of our packet. Yeah, I was just making sure we're in
it's
the same.
1.2 under that,
So just 1.2 specifically.
just specifically.
Yep. Well, yeah, so we've been doing, meetings every few weeks. The players have been at the table, the mayor, everybody. It's an exciting opportunity that we're putting in place. We want the community to know that the next tiny home village is on the horizon, and it's moving fast also. So this is that official lease, but discussion about utilities across the highway and everything's been happening. So pretty exciting.
And thank you very much to the city of Redmond for taking a very active role in development of these 12 acres and in my opinion, rapidly accelerating the development of these facilities that our community needs.
And I know that it does need to, open by January 9th of 24?
January 10th.
Oh, the 10th. Oh, you've got an extra day. Okay. That's good to know.
Yeah.
We'll probably need every day, right?
Yes, we will.
Okay, good.
Is there a
Of
motion?
24. Yes, I move approval of document number 2023-636, the ground lease with the city of Redmond,
Minus item number 1.2 on page 1.
amended per Katz Zucker's.
Second.
There we go. Okay, any other discussion? Calling for the vote, Commissioner Dare,
Yes.
Commissioner Chang,
Yes.
and Chair votes yes. Anybody else want to say anything? I mean, thanks for joining us today. Okay, counselors, thank you for joining us. Got that done.
Thank you, Christy. Never ending.
So yeah, campus downtown parking project. And then we do have another added item. At this time, we might take a break for lunch if we wanted.
Oh, can we
You wanna-
just keep going? But I just wanted.
You want to keep going? How about yourself?
Oh, I mean,
I know, yeah, I'm just
We had
acknowledging,
hoped
I'm just acknowledging the time, yeah.
day over at the.
So let's take a
But I think
3-minute break and then we'll
do
get to this item.
right now.
Yeah, we're gonna take a 3-minute break. Stand up after a couple hours.
May-
the downtown campus parking project. Thanks for sticking with us today, and we're going to get through it. Oh yeah, we wait for the camera. I think the mics are on. There you go.
Okay, commissioners, thank you very much. We'll start with introductions. I'm Lee Randall, Facilities Director. We also have Henry Alaman, I believe, with OTEC Consulting online. And he joins us. We'll let him introduce himself, but we'll do introductions and then we'll begin.
Eric Nielsen, Deschutes County Capital Improvement Manager.
Nicholas Spiros, Civil Engineer, HHPR.
Joe Bestman, Traffic Engineer.
Hello, thank you. So Henry, are you online? So Henry Alleman may be online. And if he is, thank you very much for joining us. You can bring him in. And thanks for standing by, Henry. Okay. Slides, yeah.
So we were last here with the board in December and provided an update and received direction to move forward on 4 particular items, which we'll be updating you on today. And then we'll be reviewing some concepts with you for physical improvements to the downtown campus and be ultimately seeking some direction to move forward with an amended contract for HHPR to move forward with these projects that we had budgeted for in the FY24 fiscal year, which we're just entering. So with that, I will turn it over to Nicholas Spiros with HHPR and we'll move forward.
Great, thanks, Lee. Yeah, we got a little presentation here we'll run through, and Joe and I are going to alternate on the slides. And let's see. All right. Just a quick agenda. We'll talk about the phase 1 work we've already done. We'll talk a little bit about what we're proposing in phase 2, the next steps, and then be available for any questions and discussion. Let's see, phase 1 work to date. I'm going to pass it off to Joe.
All right, we're going to be brief because we know we're a little bit behind. So really the purpose of our parking study is our next slide. Let's see. Oh, sorry. One more. Yeah, purpose of the parking study is really to assess our current demands within this campus. How well is it working for the various types of people that are coming here, staff, employees, visitors, and then looking at those future needs as well, especially with the courthouse and the changes that are going to occur to parking with that facility. Next slide. Our boundary, you guys are all here, kind of know what the boundary is, so I don't need to belabor this point too much, but it's really this downtown campus that we're looking at. On the next slide, what we've done so far is we started out with a literature review, staff surveys. We've gone through, done detailed parking inventories, physically, looking at every single sign, every single parking stall. Nicholas's crew went out, had a drone fly in a couple different days in the fall, took detailed aerial photographs that we then correlated back so we could get these parking profiles. So we have a lot of information, and we do have some preliminary phase 1 findings that we shared with you previously. And really that was showing that the current campus supply of parking is adequate. The allocation is a bit lacking. Just because you have a stall open, it might be in the fleet stall. It might be a designated for a certain type of person that doesn't fit the demand. So the space is there, the allocation is not quite correct. The other thing we noticed too is it's not as easy and as simple to get between the different buildings. We've really got to figure out how to interconnect this campus a lot better so that no matter where you park, you can get to the doors of any other building. And I think even wayfinding, especially looking at the portals, the main entry points into the downtown, you're weaving through other uses, other buildings. It's not entirely clear. So just trying to figure out that wayfinding and giving people, a better sense of, if you're a visitor, go down this route, park in that parking lot. The next slide, this kind of shows you a couple things. One is that we have a large supply of parking. I think it's 788 total stalls within the campus when you look at the off-street and the on-street system, and that's broken out in various ways. One of the key findings too is all these different signs you see in the margins of this slide are all the different types of signs on this campus. So, as a visitor, as a guest, you're really trying to figure out, where am I going? And when you get there, you have to validate, okay, am I allowed to be here? So our phase 1 really ended with identifying that we've got to figure out how to simplify the campus signage. We've got to consolidate down these numbers of signs.
we've got to make sure that we can connect with accessible routes between the buildings, between the parking to the doors. And make sure that visitors still have that priority. We're putting the visitor spots as close to the building entrances as possible, followed by staff, followed by fleet. And then finally, just making sure we have the different transportation modal options. So if someone wants to ride their bike or walk, there's not barriers that would preclude them from doing that. So bicycle parking, having access to showers, transit routes, that those types of things. So really, that was our first phase. I'll turn it back to Nicholas.
Yep. So now we're looking at phase 2. And the phase 2 task summary is really just a carryover from our phase 1 summary: campus signage, parking management, accessible routes, and campus traffic demand management. Let's see, back to you, Joe.
Yeah. So our first task within this is really just to do it, I guess. All those things we just said, it's really to go through and figure out how to simplify, how to consolidate. So I don't need to belabor this too much. The second slide here, go ahead, Lee.
And I'll just add that there's a parking policy component of this that as staff will be working on to bring back to the administration and for the board to review. And that's really making sure that our signage clearly aligns with our parking policy, so that when visitors come in, they know exactly what spaces by policy are available. And the same is true for staff and fleet parking. And currently there's some misalignment there that we want to correct. Per our policy, visitors are clearly allowed to park in permit parking when the visitor spaces are clear, but our signage doesn't necessarily follow that. So we had waited to address the signage issue until this study was complete, until we had direction to move forward, so that we were really addressing signage and wayfinding as a whole across the campus and not in a piecemeal fashion.
And so the next task 2, parking management, really dovetails into task 1. You can't just go changing signs without kind of understanding that bigger picture of how you're going to, allocate the parking stalls and figure out where to place fleet. What we found is, our fleet parking in particular is really interspersed. It's really dispersed. It's located in little pockets here and there and everywhere throughout the campus. And if we start thinking about, moving to different alternate fuel technologies like electric vehicles that require charging, we can't run chargers to every single one of these parking stalls. In addition, we've got this supply of fleet parking, these 150 stalls right now within this almost 800 parking supply. So just trying to figure out how to best manage that, how to best share those resources and have those available as they're needed for all the different functions that are being conducted from this campus.
All right, back to me. And then task 3. So as alluded to, we're looking at improving the connectivity, safety, and access between the parking areas and building entrances throughout the campus. We've initially identified 4 projects that we've listed here in order of priority. 221 Lafayette, just this away, the Wall Street parking lot, the Deschutes Services Building parking lot, the north side here, and then across the street, the Mike Meyer Building parking lot. And we'll quickly run through those concepts here. So the first one is the 221 Lafayette Avenue parking lot. The goal here, or one of the reasons it's at the top of the priority list, is to support the courthouse expansion with additional laydown area and also provide some additional parking. After that, we anticipate it would be future staff or fleet parking for that area. The second one is the Wall Street parking lot. Fair amount going on here, but that would also support the courthouse expansion projects by providing additional parking. We'd also look to provide or improve pedestrian access to the buildings on the north side of the lot, and then also in the north-south direction going down to Lafayette Street. And then we're also putting a property tight sidewalk on Lafayette Street to get those pedestrians away from the vehicles and improve that level of stress.
We are not touching Morrell Park. Not touching it.
Yeah. So one thing we provided, if you look closely, it may not show up on the screen well, but there's a dark line there that illustrates the tax lot for Worrell Park. And so as you can see, essentially the proposed improvements are around the perimeter of the park. And at this time, this concept in particular doesn't propose specific improvements to Worrell Park. And we can pause at this point after having talked about those first two projects in case there are any specific questions you have about either of those. I'll just add from a budget perspective, we budgeted for this fiscal year to be able to complete likely one of the projects, begin the second project, which would carry over to next year's budget. And then we've in our 5-year outlook plan planned for continuation of these projects in our long-term planning.
Well, so yeah, back to the last slide. I mean, that is acknowledging that there's a small house there that's going to be removed at some point. So that's the reality of that situation.
And
which is a property we purchased and knowing that we're going to need to utilize space.
And with this map, I mean, there's not currently parking stalls immediately on the north side of Worrell Park. I mean, is that kind of nibbling into some of the lawn area that currently exists, or is that just reconfiguring the streetscape that's already there?
Yeah, I'll maybe give a summary, then you guys could speak to the engineering portion of it. There's a few things that of our goals that this addresses. One is trying to provide visitor parking closer to a building for the services that folks are trying to access at that building. And so one issue we currently have is that folks visiting the Wall Street Services building need to cross a fairly active drive aisle. And so one of our goals was to provide some parking along there. Big picture, as we've looked at these projects, we've tried to look at areas where we could add some parking capacity that would help address some of our goals of providing better access to buildings while not really making the project all about capacity. So then to your question in particular, it does move into some of the lawn area. We also have a fairly wide sidewalk there.
On the north side of the street. Yeah.
Yep. And so there's a large sidewalk that it would accommodate. It also realigns that whole drive. Currently, that's a very sharp turn. And so for safety purposes and slowing people down and making that a more natural turn, it realigns that so that the new drive is somewhat further south. But still we're able to utilize the ballot drop box and the tax drop box area. But I'll let the team talk to some of the engineering components of that.
I mean, I don't know that I have much to add to that. Yeah, I mean, we're adding more parking, like you said, we're adding some pedestrian crossings to just facilitate that, pedestrian movement between the buildings. And we, yeah, I mean, there's some stormwater upgrades in there as well, but those are kind of the high level items.
We've tried to kind of band-aid that entrance too with that channelized island to try and slow down traffic coming in. And I think this realignment really goes a long way in making sure that's a more conventional expected entrance. And I think it then dovetails back into this discussion about, where are the portals into this campus? And that's clearly going to be improved as one.
I think the last item I'll point out is accessibility in the broad use of the term and specific to ADA was at the forefront of what we looked at across all of these projects. And so you'll notice in the Wall Street lot on the north end there close to the Wall Street building, but on the south side of the drive, currently the accessible parking is up against Wall Street and there's no access to a sidewalk directly from the accessible parking. So this plan moves it across up against the park. And then with adding the sidewalk, now if someone needs an accessible route, they're going to be able to exit their vehicle, use a standard van unloading zone, access a sidewalk, and then that sidewalk will be their route to multiple services on the campus. Currently, and you'll see in some of the other proposed projects, we're trying to address those accessible parking stalls that are kind of out on an island by themselves. Technically, they may be accessible, but they're not best practice in terms of getting people from where they park to whatever service they're trying to access.
And there's also on there, it's kind of hard to see at this scale, there's a new sidewalk along that easterly edge of parking that runs in the north-south direction. You know, currently there's no walkway at all in that parking lot in the north-south direction. So they'll provide some connectivity down to Lafayette Street from there, Lafayette Avenue.
And you'll see that theme in the next couple of projects of trying to provide collector pedestrian routes to pull people out of vehicle aisles so that they're in a safe space as they switch from being a driver to a pedestrian and then access the building services.
You've been in that southeast corner of that parking area too. The geometry is really tight with the islands. There's some fleet parking that's kind of on the east side of that southern access onto Lafayette. So this also cleans up that side of the project too.
Any questions on the first two projects?
I guess the one last thing I would ask or say about this teeny little bit of loss of a teeny little strip of grass on the north side of Worrell Park is it would be good to communicate with the Save Worrell Park advocates, just make it real clear that, you know, and I remember them saying, you know, if you were going to, you know, shave off a little edge of Worrell Park anywhere, this would be the spot where they supported. But just to make sure that they're really clear that this is all that's being proposed, you know, that this is, you know, when they see machinery out there, it's nothing's going to happen to the rest of them.
So how much of it are you planning on taking off then? I mean, what is the allocation? It's like 1.06 acres, I believe, or something like that.
So actually, the areas that this proposal touches are not part of the park officially. So they're
Okay, not part of the tax lot,
correct. They are not part of the tax lot that we're
but they are the visual park. So, okay.
It's looks like about a parking stalls worth of length. I mean,
Yeah, it's probably a 20-ish foot strip along that edge. 25-ish.
no. I mean, if these lines are actually to scale in 11 or 12 new spots, right?
I think I don't have the numbers in front of me. I think we're looking more like 30, 25 spots.
Yeah,
But just on that
Or
side.
just on that edge there, sorry. Yeah.
about 11.
Yeah. You're taking up those couple of tables on the health services side of the street, that'll get you more, but.
Yeah, and we also plan, you can see some very small black lines there that illustrate picnic tables. So we've tried to continue to have a space for picnic tables in the shade along the Wall Street Services building, and then room for a couple on the south side of the drive. I think, Eric, were you going to add the total number of parking stalls that are gained in this?
Yeah, this plan here proposes an addition of 29 stalls gained overall, and then the Lafayette project would gain us about 5 stalls. So between the two projects, 34 stalls. Yeah.
Can I just ask, are they standard 8x18? Are they 9x20? What's the configuration of the stalls you're
I
proposing?
believe they're all standard full size 9x20.
Okay.
You know, the vast majority at least.
And those 29 stalls really represent trying to move, even though it's a fairly small number, that represents a significant increase in capacity of stalls against the building that are very close to the entrance. So in terms of percentage of stalls that are going to get people more quickly to services, it's a pretty big improvement.
If I could just ask one other question, you know, one of the peak times when we need parking is during elections. Would you see these stalls being closed down or roped off or something of that nature during elections, just given that heavy traffic that comes through?
We would probably, that's a very good question. It's something we've talked about a lot. We would probably, we would take it on a day-by-day basis. So typically how we approach elections is we create a plan. We have additional steps that we can take if things get congested. I would say that likely the stalls up against the park, those 11 or 12, we would close down as part of our initial plan, and then we would monitor the other ones. One of the problems we have in that area would be someone backing into a line of traffic that's lined up at the ballot box. We So this parking may not come into play during the heaviest ballot drop-off times. But there are times during the election when the ballot box isn't utilized. So on election night, once the ballot box closes, there are other times where we would be flexible and reopen it, close it back down to make sure it's safe. So those particular stalls along the drive aisle may not contribute to additional parking during election. On specifically on the heavy ballot collection days.
Great question. Okay.
All right. Our third concept here is the north parking lot for the Deschutes Services Building. And the goals here would be to improve accessibility through that parking lot all the way up to Norton Avenue, and then adding a sidewalk on the south side of Norton Avenue where there is not one now, and then adding a crosswalk on Norton Avenue to connect to that lot on the north side. Just currently a bit of an island now.
A lot of people walk through the bushes there to get to their.
And it goes back to, if we're telling staff, hey, you're gonna have to park in the back because you're not the visitor. It's telling them, but here's a route that we're gonna prioritize maintenance and plowing and everything else on to get you back to the building doors.
And the fourth one, the Mike Meyer Building just behind us. We're looking at improving accessibility. It's kind of hard to see on this picture, but currently the accessible stalls right now are on the north side of the parking lot, and then they have to cross the parking lot. Typically you'd want those stalls right up against the building. So we relocate those, and there would need to be some regrading to make that happen. There would be some updates to the stormwater. And then this parking lot is quite dated, so there would be a resurfacing of the entire parking lot, which would also facilitate redoing the grades to make it more accessible.
And how many spots are you gaining then at that spot location? Nothing?
That one, I don't think we probably would not be gaining any spots on that one.
We may look at changing the signage on some of those, though. That's still up for further review and discussion to make them more available.
As Lee mentioned, the first two projects are kind of at the top of our list. We'd start there, and then the plan would be to move on to the other ones. But those two are most supporting the courthouse expansion, while also the biggest improvements for safety and accessibility.
Then as far as campus TDM options and strategies, it's really just trying to, again, make sure there's not barriers if someone wants to walk or bike or take the bus. And with the courthouse project, we do have to move the transit stop a little bit east for safety and security reasons. So just making sure everything is tied back in and interconnected. We've been already working with Cascades East Transit as well as Toby Marks with the City of Bend's downtown parking planning.
So just recapping, the deliverables for this phase 2 would be recommendation for campus parking signage, provide a recommendation for parking management strategies, the accessible routes, and parking improvements, take those from design to construction, and then recommendations to improve the multimodal campus access. And let's see, next steps, as Lee alluded to, we would come back with a contract to do this work, and then, basically do what we just talked about, develop the recommendations for this, the signage, the parking, the TDM strategies, continue advancing the concepts into design and construction, and be sure to communicate with the downtown Bend partners and other stakeholders.
Great. This is
question
that we need to execute on in support of a courthouse expansion. This is just some of those pre-projects, making sure there's enough parking, and it's going to be nice that these flow upgrades, the few sidewalks, a little bit of marking. It'll make it just a nicer downtown experience when they're coming to county services.
So Lee, I'm hearing that the box factory area is they are so impacted because they don't have enough parking. We need to come up with something really clever and inspirational. So people will actually get in that, maybe park here and then take it down to the box area. That's what, 3 years away before their parking is ever going to be adequately addressed. I feel so badly for the businesses there so anyway, I know didn't we use the parking lot for when Downtown Bend was having an event recently, and we did that in 19, and we are actually so close. I walked to lunch a couple times and it's actually so close. I can't believe it. But we need to really help facilitate whatever we can do. Somebody out there has to have a really great idea. I don't know if we need a horse-drawn carriage or something, but some way to get people to park here, but to go to the box factory.
And we've met several times with the city of Bend, specifically with Toby Marks. That is specifically one of the concepts we've talked about. Christy and I are currently working on a agreement with the city of Bend for use of the parking. They were still waiting to figure out, the nuts and bolts and mechanics of how they would get people from here to events. But we're in talks specific to what you're mentioning and how to utilize our parking in a way that can benefit the city. And then on the parking management strategies, one thing we want to look closely at is how can we leverage the capacity that we have in the off hours to benefit not only the city, but to benefit the county potentially in how we manage it. And so there are a lot of new technologies that allow for after hours use of parking lots and tracking and payment. And part of that parking strategy and management part of the tasks that we outlined is something we'll pursue as part of that task. So we're excited to look at that more closely and make sure we utilize the space that we have.
I know it's amazing how many parking spots we have already. So definitely helping the community.
So there's a proposed motion to acknowledge and have staff proceed on phase 2.
I'll move to direct staff to proceed with phase 2 of the Downtown Bend campus parking project as presented.
And I'll second it.
Okay, any other discussion? Seeing none, Commissioner Chang,
Yes.
Commissioner Adair,
Yes.
and Chair votes yes. Thank you for being so professional on this. Look forward to the improvements.
Thank you.
Thanks so much for your brain power optimizing our parking here.
And thank you for barely touching the park.
Item number 13, subrecipient agreement for COIC and emergency housing funds. The whole thing just kept slipping today and you were here to see most of it, right? Thanks for joining us.
Good afternoon, commissioners. Thank you for your time. My name is Trevor Stevens. I'm the business manager for the Community Justice Department. With me is Nicolai Brower. She is our administrative analyst for adult parole and probation. So we are here today to seek approval for board signature on document number 2023-690. This is an agreement with the Central Oregon Intergovernmental Council for Emergency Housing Funds for Governor Executive Order 23-02. So back in May, we came before you guys to apply for a grant for emergency housing funds to help provide housing for those individuals with a restriction on their conditions of supervision that prevent contact with minors or that may have to register as a sex offender. This is one of our hardest populations to house in our community. And it just presents a challenge of accountability versus behavior change and how we manage those individuals when those individuals are camping. The accountability aspect for our POs and our officers just makes it much more difficult. So having this resource for our community would be very nice in order to really provide a housing option for those individuals in our community. Right now in Central Oregon, there is not a secure housing option for these individuals in our community. Sometimes we place them in hotels. We had a recent prison release just this last weekend. Hotels were going to charge about $350 a night just to have that individual stay for the weekend in order to get them to a point where we could get them into some other housing option. So this would be a vital resource for our community. We were approved for the grant and it'll be a pass-through grant, meaning that we will contract with a private provider to purchase the house, run the house for us, but we will be the administrative part of that in providing administrative support. No new FTE will be added for this grant. And the goal will be to have that private provider doing the majority of the services for our community. And so with that, the grant award was for $1,078,518,000, and it'll provide the ability for us to solicit a RFP to enter into an agreement with a private provider to purchase the house and run the service in our community. So I'm here to answer any questions that you may have about this project.
So the MAC has acknowledged these dollars. I mean, it was an ask and they said, yep, let's do this amount.
Yes, they approved the full amount, and the next steps will be just to solicit the RFP, find out a private provider, and then kind of work through those processes with them in order to provide a house for this service.
And you do have a private providers out there that
We have
want to take this over.
We have providers that are interested. So because of the amount of the grant, we'll need to issue an RFQP, and then we'll wait for those solicitations to come in. We also have been reaching out to 2 providers in the Valley area who have expertise in this area. So at least they can maybe provide us some support in terms of structuring our RFP, and they may have interest as well. And they've actually done this in locations outside of Central Oregon, but we do have providers in Central Oregon who've done this with other populations. This population is a little more unique, so they'll have to work through that, but we will solicit that out for everyone so they can apply and then be awarded those funds.
Right. Yeah, and I had a chance to speak with DB Holcomb about this, and she answered all my questions at that point. So if I don't have any questions now, it's not that I'm not interested.
Exciting.
Well, paying $350 a night seems a bit excessive. So definitely. And when you mention this, the population you're serving, it is really important that they are somewhere. And it can't be easy.
That wasn't because of the festival, is it?
My guess is that probably contributed to.
Oh,
but yeah, because our normal rate is probably in the summertime. We usually can find something in the $150 to $175 range, but I mean, we couldn't touch anything for under 300.
No.
Yeah,
good for transient room tax revenue, but not so good for trying to find places for your people.
So I move approval of chair signature of document number 2023-690A. Subrees to be in agreement with the Central Oregon Intergovernmental Council for State Emergency Housing Funds.
Second.
Is there any other discussion? Seeing none, Commissioner Dare?
Yes.
Commissioner Chang?
Yes.
And chair votes yes.
thank you, commissioners.
All right.
Thank you. Thank you for your patience.
Standing by, yep.
Great project.
But this time, other items, we're wrapping up now.
They must have come back for a reason, right?
I think so. Same crowd from Monday.
Thank you, Chair. Eric Crop, Deputy County Administrator. Speaking of parking, we were approached by a local church that has an event in Drake Park. It's on the weekend. They have a large number of people that attend the event, and they asked if they could use our parking lot over the weekend. I don't know which weekend it is. So what we could do is either tell them that the county parking lot is available on the weekends. We don't enforce permit parking on the weekend, or we could do some type of agreement with them so that we have insurance coverage by them, and also have some language about they would need to clean up any trash. Not that I would suspect that, but we could do just a lease or some type of agreement administratively. One thing to keep in mind is if we do that and get requests from other churches or nonprofits, we kind of set a precedent for saying, yes, we wouldn't be able to say no based on the type of group it is. Obviously, we could say no if we had other things going on in the county parking lot that weekend. But I just want to make sure that the board is fully aware of that. Or we could just say, no, but you're welcome to park here.
Well, I think we've already basically offered it to the downtown business zone. I don't know if we have an agreement of any sort, but knowing that this could be the overflow parking within walking distance of downtown.
Yeah. I mean, previously we had an agreement with the city of Bend, so this would be a little bit different. But logistically and from a facility standpoint, we don't see an issue with it. I talked to both Christy and Lee, and we acknowledge that this is a public amenity, and on the weekends, if it's not used, there are some benefits to allowing groups to use it. Again, just with that caveat that if we get requests from other nonprofits, we would not be able to say no based on the type of nonprofit it is.
Well, I mean, if it's available.
So no board action required, but just wanted to see if there's any concerns from the board.
No concerns.
Okay.
I think it's great that people are recognizing that we have a lot of parking spots here. So, and we're pretty handy.
Okay, we'll move forward
Thanks, Art.
administratively. Thank you.
We have a community development.
Yep, community development.
Continuation from Monday's discussion.
Good afternoon, commissioners. For the record, Avery Johnson, Assistant Planner. As Anthony discussed with you all on Monday, we are here to discuss whether or not the board wishes to call up a hearings officer decision on an initiation of use application. This most recent decision follows the rationale of the decision we discussed on Monday. And again, the hearings officer found that the expenses incurred prior to land use approval should be counted towards a good faith effort to establish the use. As we discussed on Monday, staff and legal are concerned that this decision could give property owners the impression that they can and should begin development prior to land use approval. So today I'm here to ask whether the board wants to call up this hearings officer decision for review.
And specifically, we're talking about a hearings officer decision on file number 247-23-000-125 DR. Again, it's a very similar decision to the one I sent you last week that we discussed on Monday.
So when we're talking establishing the use, we're referring to a land use approval that has expired. And then now this is declaratory ruling, acknowledging that something happened in the previous time period. And yeah, use is established or not is what the ruling is at.
Whether or not the owner or developer demonstrated a good faith effort to establish the use. And so again, the call up would be in staff's opinion to address whether or not those expenditures incurred prior to the land use approval should be counted.
Mm-hmm.
And again, historically, we have not counted those types of expenditures.
Kind of like a vesting argument, essentially, that you're saying, I granted you something. What did you do to vest your interest in that? And I think the question they're articulating is, can actions and money you spent before we even gave you the right apply towards determining whether you vested it, whether you established it?
And so again, as I mentioned on Monday, our procedures ordinance allows the board to call up any administrative or hearings officer decision for review absent an appeal. So the decision actually will be mailed out. It's probably being mailed out right now. We're doing a hand mailing. And so the board has essentially 12 days to make this decision during the appeal period, but recognizing that, I believe, if I'm correct, there are no meetings next week, felt it was important to get to you today.
And I think the thing that was helpful based on our coordination earlier is that while the board could wait until August 7th to call it up, if you call it up sooner, they could begin the notification process immediately because there is a clock issue. I mean, there's
still a tight clock.
time, so that's just timely to make the decision on the call up.
That's correct.
And then the value is a board decision opposed to hearings officer's decision, which would feed back into other hearings officers' kind of logic or precedents for decision making.
Yeah, as I mentioned on Monday, hearings officer decisions do not create precedent for the county, but your decisions will. So really, and again, it's setting a guideline for interpretation of our own code so that not just hearings officers, but developers, property owners understand what is expected of them in order to establish a use.
Yeah. Is there support for calling this up?
Yes.
So
I'm still stuck on the fairness of calling this one up, but not calling the other one up. I'm just going to abstain on voting on this.
And for Commissioner Chang's benefit, as I mentioned on Monday, if the board chose not to call this up, really what we would do is if someone were to use this rationale, we would send that to a hearing and then the board could call it up, a future application. So we have we have a plan to deal with this if the board, for whatever reason, chose not to hear this one, fairness or otherwise. We have a plan to deal with this in the future.
Well, and my thought is to just, shed light on the concept. And that's why I would support this at this time. Let's not let people think that, there's a precedent, a new precedent to set, even the challenge to that precedent, even if it's not a precedent.
Sure.
So can you mention the file number again for us, please?
It's 247-23-000-125 DR. That's the board order number. And Avery has drafted a board order, and we'll get that to Brenda, assuming the board wants to hear it. And then really the other decision to be made is what form of hearing would the board prefer? We of course have full de novo testimony you can receive, testimony you can ask questions. There's limited de novo where you limit the issue areas, or on the record, which is purely just a review of the record to date, no new evidence and testimony. And the hearing really is just an opportunity for the board to ask clarifying questions of items that are already in the record. So there are pros and cons to each, given frankly, the lack of other participants and the narrow issue areas. Full de novo, I think would be appropriate here.
And I was thinking the other way.
And you can, and you absolutely can.
As you're explaining that.
Sure. And, again, it's really at the board's discretion, what form of a hearing you want. The only reason I was going to suggest full de novo is it gives staff and legal counsel an opportunity to put a memo together to really in writing explain our concerns.
Oh, I see.
So that's, if we go on the record, then that option goes away in terms of adding new testimony into the record.
Well, and yeah, we want to hear from all aspects, and it opens it up right there. So that's a good justification. So yeah, if you're supportive, I'm available for a motion.
Okay, so I move, are we talking resolution or what are we talking?
What we have is order number 20.
Order number. Okay, thank you.
2023-0.
I have them 0000125 DR. Is that correct?
That's the
Okay, I move we approve order number 247-23-000-125 DR.
That's the file number.
The file-
Anthony can give you the board order
The
number.
order number is 2023-032.
Okay,
So that's the order number for your motion.
2023-032.
032.
Oh, that's easy. Okay, order number. So move.
De novo, full de novo.
Full de novo per Anthony's recommendation. Dave, did you have any difference of opinion?
No, we agree with Anthony.
Okay, I just want to be sure,
Always
since
Ah.
I'm sitting by him.
Yeah, there you go.
I'll say for the record, that's a bad idea.
Oh, I agree with Anthony.
He could elbow me if he wanted to do something different.
Okay, so
Bad idea.
I'll second it, and we'll go from there. Any other discussion? Seeing none, Commissioner Dare,
Yes.
Commissioner Chang,
Staying.
and Chair votes yes.
Thank you very much.
We'll be reviewing this
Before
topic.
And I talked about this a little bit on Monday. The notice of public hearing will go out either tomorrow or Friday, and then we'll be prepared for a hearing on August 9th, Wednesday, August 9th.
Busy day.
One last thing,
It'll be the follow-on for today.
given the discussion already, I wasn't planning on doing a work session on the 7th, that Monday, but if you want one, we certainly could. I wasn't planning on it just because I think we've discussed sort of the issue areas, but we can't.
So yeah, let's reach out to see if each commissioner maybe want to spend some time.
Okay.
Maybe
I will
not
do
in
that.
work session, but just in preparation.
Okay, thank you so much.
Thank you.
Thank you.
Anything
If
else?
we just have a brief update on the chamber.
Oh, all right. Okay.
That's August 8th.
We're getting there. 1 o'clock.
Till August 7th.
Thanks for being patient, everyone.
Thank you.
For the record, Stephanie Robinson, Administrative Services, and I'm here today to do a final review of the presentation for Ben Chambers' What's Brewing series taking place Tuesday, August 8th from 5:30 to 7:30 p.m. I did get some feedback on the slides from Commissioner DeBonne to potentially update the title of the slide. And then I also added a draft slide going over kind of the history of solid waste in the county. And that's the second to last slide in the presentation.
Did you create that slide or did somebody have it?
I created it using some information I gathered.
Yeah, well, and yeah, so we can make sure it reviewed by solid waste, which maybe you already did. But that's great. Thank you. So getting back to what you started with. So the title, it says what's brewing in Deschutes County, and we're responding to what's brewing for the Ben Chamber. So my thought was maybe we have our own title. You know, we're at the What's Brewing event, but we don't need to name ourselves What's Brewing because that's what we're doing. If we had something else, and I'm not even proposing what it would be, but it was just as you look at the front page, you know, what else would we want to say there is the concept. So if anybody has ideas.
I feel like we were invited and that the chamber had very specific topics that they were interested in hearing from us about. And I'm not against us giving some general information about, you know, about the county overall, but I think if we were invited to cover some specific topics, that we really need to place great emphasis on those topics and, you know, offer the folks what they asked for. So I'm concerned that with the number of slides that we've now added, we've all seen how when this Board of Commissioners gives a presentation, you know, we can spend 40 minutes talking about 3 slides. And if the 3 slides are the things that the chamber did not ask about, then I feel like we're not honoring their request. So if we're going to go with this package, I'd like us to come up with a better plan for how we get to the topics that the chamber is interested in hearing about. The one proposal I might offer would be to rather than have one of us cover the first few slides, would actually be to ask Nick if because they also specifically asked for Nick to be there. So you know, maybe Nick could cover the first these overview slides, and then when we get to the meat of the topic, which is what they want to hear about, we could then he could turn it over to the commissioners.
Well, so getting to substantive, you know, what are they asking for? Is it childcare and childcare?
Workforce housing.
Housing, yep, sorry. I was looking at 2 slides and they were both the same topic.
Yes.
And those were the specific topics that they asked to hear about, to discuss with us.
And what's your vision there then? You want to spend 20 minutes talking about each subject or both 10 minutes each, or I don't understand.
I'd like this to move very quickly through these first 6 slides, spend some time presenting the housing and childcare topics, and then leave a meaningful amount of time for people to ask questions. And
Okay, well, yeah,
have it be question driven as opposed to you know, us filling 55 minutes and leaving people 5 minutes for questions, which is happens.
Oh gosh.
On a regular basis. So.
Okay, well, so I'm glad I asked then. So even for workforce housing and childcare, you don't want to spend a lot of time on it. Because you start off by saying they've asked for specific things.
I think those,
when you spend a lot of time.
Topics, what we could say, I mean, you know, what we're presenting, I mean, I think we could cover the housing and childcare slides, those 4 slides, 10, 15 minutes tops. And if the other stuff is just a couple of minutes, then.
So, yeah, but that's your goal, is to get through all the slides and just leave it open for questions and get good conversation started.
My goal is to, number one, you know, give some substance on the specific topics that they asked about, and number two, to leave time for questions, for it to be question directed.
Okay, so this set of slides, you're saying this is kind of the proposed set of slides. I mean, there could be changes, but we could be done also.
You're welcome to edit, and delete slides.
Yep.
And also go through each slide and just kind of quick talk about who's going to speak to that one. So there's kind of a plan and structure.
So we have 15 slides and how many minutes do we have? 55 minutes?
Let's see, 15 minutes for the panel discussion, and then there's another 15 minutes on top of that for Q&A.
Oh, okay. So that's like 3 minutes a slide.
Well, and I think this is pretty tight already looking at it. So I mean, the first one is just a nice statement with a babbling brook. And then we just list off services and partnerships, the org chart of the county. So I mean, I'm not seeing this as a long presentation. And then we jump right into workforce housing, rural ADUs, which is our content. So I guess we would need to be careful about not getting, so like what happened, which was wonderful, but somebody's gonna ask about how can I authorize my existing non-conforming structure, and then we could talk about that for an hour if we're not careful. So rural
Bring that up
ADUs.
during the Q&A.
Yeah, so that's my point exactly. Getting through this slide and not finishing our slides. So that's exactly it. So maybe the most valuable thing is to maybe let somebody ask a question and just put it in a parking lot as fast as it happens. Be ready for that. And that'd be good, Nick. I mean, if you could say, okay, let's acknowledge that question, and then move on, because then we can finish our slides and get to the Q&A. So workforce housing investments, childcare. Okay, well, and I would like to speak solid waste a little bit for the group. It'll be interesting to see how many people come. So workforce housing investments. Do you want to take a whole section like that, Commissioner?
I could, but
Either workforce housing investments or childcare?
like I said,
I'm seeing
I think
three
it'd be,
pieces.
I think it'd be great to have someone besides the three of us who can be very long-winded, cover the first 1, 2, 3, 4, 5, 6 slides.
Some people call us politicians. Maybe we're expected to be long-winded. How about I do the introduction?
Not the stuff that the chamber asked for.
How about if I do the introductory slides up to workforce housing? Either one of you can do that, and then one of you can do childcare. And then we'll finish up with hot topics, and we can be done in, those.
Who's going to do the rural ADUs, and you're going to put those with the workforce? Yes.
Mhm.
Okay, so you're going to do those 3
1, 2,
slides,
3.
and then
I'm
I
just
can.
thinking that we could break
so-
it into 3.
Okay, and then I'll do the childcare. Oh, thank
Want
you
to
so
do
much.
housing investments?
Sure.
Workforce housing.
We'll have a timer going, and if you go over, Stephanie will press the button, right? We
That
can
would
do
be great if we actually had a timer for
Okay.
Oh, we got a beautiful, that 3-inch lit timer. We can put it on the
Yeah.
counter.
Brenda, did you hear that?
Oh, go ahead, bring it.
Nick
We'll
will be
do
in
it.
charge of the timer.
I don't mind. Because I agree. I mean, sometimes you answer a question, all of a sudden it's been 10 minutes later.
Well, I mean, it's often not about questions. It's just about the expounding that any one of us wants to do about what's on the slide.
Okay, well,
I think we're good.
okay.
Yeah.
So I'll do all the introduction stuff.
Right.
Just the basics. Workforce housing will be you, childcare will be you.
Yep.
And then,
We'll add- And somebody will definitely ask about solid waste because we'll have a slide up.
and I'll finish with solid waste. So I guess, I'll just talk about that topic. And I did talk to the chamber board already very specifically on this. So I'll just talk about citing a new landfill. We have a solid waste advisory committee.
So
Okay, general structure.
Yes, I'm good.
we're good.
Good. All right, perfect. I'll send this to the chamber. I'll run the slide past solid waste. Send this to the chamber, and then also send a final copy to each of you.
Great.
Thank you.
And then, yeah, I mean, time wise, go ahead and send an email to us asking for info one more time, just in case there's slight edit or change or idea, but we'll think pretty much it's getting done. Thank you. Anything else you see? So I'm going to go to horse fair this afternoon at the fairgrounds and check in with everybody just to say hi. This is the pre-event for the fair itself.
Wonderful. Maybe
Anything
they
else?
can get some press before Sunday morning.
I know, that's.
No,
Anything else?
I mean, we've seen how the numbers are going down. 4-H really needs a big push from
The media,
the media.
there we go.
Yes, really. And these kids work really hard. So,
Okay, meeting adjourned.
thank you.